morning and welcome to the public hearings for the inquiry into the acquisition of land in relation to major transport projects. Before I commence, I'd like to acknowledge the Gadigal people, who are the traditional custodians of the land on which the Parliament sits. I'd also like to pay respects to the elders past, present and emerging of the Eora Nation and extend that respect to other Aboriginals present or who may be watching today. Today's hearing is being conducted virtually. This enables the work of committees to continue during the COVID-19 pandemic without compromising the health and safety of members, witnesses and staff. As we break new ground with this technology, I'd ask for everybody's patience through any technical difficulties that we may encounter today. If participants lose their internet connection and are disconnected from the virtual hearing, they're asked to rejoin the hearing by using the same link as was provided to them by the committee secretariat. Today we'll be hearing from some Orchard Hills residents who are impacted by the acquisition of land for the Sydney Metro Western Sydney Airport project, along with representatives from Sydney Metro. Before we commence, I'd like to make some brief comments about the procedures for today's hearing. While parliamentary privilege does apply to witnesses giving evidence today, it does not apply to what witnesses say outside of their evidence at the virtual hearing. I therefore urge witnesses to be careful about comments you may make to the media or to others after you complete your evidence. Committee hearings are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it's important that witnesses focus on the issues raised by the inquiry terms of reference and avoid naming individuals unnecessarily. All witnesses have a right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. There may be some questions that a witness could only answer if they had more time or with certain documents to hand. In these circumstances, witnesses are advised that they can take a question on notice and provide an answer within 21 days. Today's proceedings are being streamed live and a transcript will be placed on the committee's website once it becomes available. Finally, a few notes on virtual hearing etiquette to minimise disruptions and to assist our Hansard reporters. Could I ask committee members to clearly identify who their questions are directed to? And could I ask everyone to please state their name when they begin speaking? Could everyone please mute their microphones when they're not speaking? Please remember to turn your microphones back on when you're getting ready to speak, and there is always one. So if you're that one today, it's okay. If you start speaking while muted, please start your question or answer again so that it can be recorded in the transcript. Members and witnesses should avoid speaking over each other so that we can still be heard clearly. And to assist Hansard, may I remind members and witnesses to speak directly into the microphone and to avoid making comments when your head is turned away. Right, with that out of the way, I now welcome our first witnesses. First, could each witness please state their name and position title and swear either an oath or affirmation, starting with you, Mr. Vella.
Hi, my name is Jesse Vella. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you, Mr. Vella. Mrs. Vella, could you please state your full name and position title and swear either an oath or affirmation?
My name is Lauren Vella. I'm an Orchard Hills resident. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. Mr. Severus, could you please state your full name and position title and swear either an oath or affirmation?
My name is Victor Shibris. I'm talking on behalf of my mother, Carmen Shibris, which is a resident. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you, Mr. Shibris, and apologies for getting your name wrong to begin with. Mr. Kohler, could you please state your full name and position title and swear either an oath or affirmation?
My name is Luke Kohler, and I'm representing myself and my brother James Kohler, who own a property in Orchard Hills, getting acquired. And I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Fantastic. Thank you all so much for attending this hearing. I know it has been a long time on the cards before we could make it work. given COVID restrictions and all the rest of it. So we're very, very pleased to have you here today. Would you like to start by making a short statement, if you could keep it to no more than a couple of minutes? And I'll start with you, Mr. and Mrs. Vella.
Good morning. My name is Jesse Vella and I'm here with my wife, Lauren. First, I would like to sincerely thank the committee for inviting us to provide evidence today. Our home was acquired by Sydney Metro last Friday. As a result, we've encountered firsthand the flaws of the acquisition process and the harsh constraints of the Just Terms Act. As impacted residents, we would like to raise the following concerns. The acquiring authority acquiring more land than was necessary for the construction of the public purpose. The legislative requirements regarding market value assessment resulting in unjust compensation. Impacted residents being financially disadvantaged by no fault of their own as a direct result of the acquisition. Finally, the inability for landowners to be reinstated back into our suburb of Orchard Hills in a comparable property due to inadequate compensation. I have a deep connection to the suburb of Orchard Hills, as this is where I've lived my entire life. Many sacrifices were made by Lauren and I in order to purchase our property. On the 11th of September 2020, we were informed by the Sydney Metro that our newly renovated home would be acquired for the public purpose. This news came as a shock to us, as we were informed 3 months prior by a Sydney Metro representative that our home would not be acquired. Upon the release of the environmental impact statement, it was evident that the scale of land being acquired in Orchard Hills was far greater than any other metro station in New South Wales. Sydney Metro have acquired approximately 65 acres to construct the Orchard Hills Metro Station and line. This figure excludes the land being acquired for the stabling and maintenance facility area. In comparison, Sydney Metro had previously acquired approximately 40 acres to construct the entire Sydney Metro West Line, which includes the total of 9 stations. A tunnel will be constructed approximately 20 metres below the surface of our property, without any impact to the surface post-construction. Sydney Metro confirms that the freehold interest in our property was required for the construction of the project. For this reason, we offered Sydney Metro the right to acquire a leasehold interest of the entire parcel of our property for the duration of construction and the right to demolish all improvements on the land. Sydney Metro declined this offer and reiterated they would proceed with acquiring the freehold interest in our property as planned and in accordance with the Just Terms Act. We're of the opinion that the acquiring authority did not make all attempts to minimise land acquisitions and were able to do so while acting in accordance with the Just Terms Act. The Orchard Hills Metro Station will service a future residential and mixed-use precinct. We believe the unstated reason for acquiring the freehold interest in our property is to facilitate the future development in the precinct post-construction. Therefore, we feel this is the reason they declined our offer to lease the property, which would have been a much more cost-effective option for the New South Wales taxpayers. We understand that there was no incentive for Sydney Metro to lease our property. However, there was a strong motivation for Sydney Metro to acquire our property, given the huge uplift in value to be captured. Sydney Metro now own our property, equal to 20,230 square metres of land within the future residential and mixed-use precinct. We believe the Just Terms Act should be amended so that if a dispossessed landowner reacquires part or all of their land, then such reacquisition is at the market price paid by the acquiring authority. Another concern for us is that when Sydney Metro valued our property, they took into account the proposed environmental zoning based on the draft Cumberland Plain Conservation Plan. This resulted in a substantial decrease in the valuation of our property. After numerous attempts to seek clarification from the Department of Planning, we reached out to our local state member. She advised us that the Cumberland Plain Conservation team contacted Sydney Metro and confirmed that the plan over Orchard Hills is a draft and questioned why Sydney Metro would use a draft overlay in valuing properties when it is certainly not final and not a planning instrument. The significant issue resulting from the Just Terms Act is actually very simple. We are unable to be reinstated back into our suburb of Orchard Hills in a reasonably equivalent property. New South Wales is the only jurisdiction in Australia that does not offer compensation on a reinstatement basis. We are not against infrastructure and progress. However, we believe that residents facing compulsory acquisition must be compensated so they have the opportunity to be reinstated back into their suburb in a comparable property. If the New South Wales government are serious about treating dispossessed landowners fairly, then there must be major changes to the acquisition process and the Land Acquisition Just Terms Compensation Act of 1991. Thank you.
Thank you very much. Mr. Shibrus, did you have a statement you'd like to make?
Hi, can you hear me? All good?
Certainly can.
Yeah, pretty much. So my name is Victor Shibrus, as I said before, and I know it's what I pretty much can't understand is on behalf of my mother, which is a 76-year-old widow. If she didn't have 7 children, Sydney Metro will have stolen what my mother and father have worked for all their life. Their first offer compared to their last offer is 73% increase. So what I'm gutted about is how a first offer can be so low and come up by 73% to the last offer, which she still can't relocate with that money back into the area. But in saying that, as a 73% increase, just shows how out of state Sydney Metro's values are. Now, luckily my mother has 7 children to fight for her. My brothers, my sisters, we've all contributed into the fight in the last year, which is wrong. People should not have to fight and argue for something they have. All my mother wanted and all we wanted was to replace what we have. The first offer was that insulting 3 months before, a couple of months before Christmas last year. We thought we were headed for, we were headed for hell. I mean, my mother has been on land all her life, and this is what people don't understand, what they're playing with, right? My mother's been on land all her life. She wants to stay on land till the day she dies. That's all she told me. So I fought for that, okay? Now, what they've offered, we can't buy land back for her back in the area. So how does a woman that's worked for 50 years in this country, something gets taken away from you, but you can't replace it and explain that to a 76-year-old widow? What I'm saying is I'm here not only on behalf of my mother, but I'm sure there's plenty other people in my mother's boat, right? The stress that Sydney Metro put my family through, that's why I'm here today. I'm a nobody. I'm Vic Shibrus, right? I can't fix this problem, but you guys can. You just don't realise what you're doing to the people, okay? These valuers and all these people, they're only doing their job. They're all getting paid, okay? Sydney, I'm gonna allege, right? And I'm alleging because I don't want to get in trouble here, but I can't understand how Sydney Metro's valuers can be so different to my valuer. And we got a couple of different valuations on my mum's property, and they were very, very similar. So how come Sydney Metro's valuers were so far out of tact? And if my mother didn't have children to fight and argue and get people involved, town planners and this, and prove what the land's worth, the land is worth what it costs to replace. It's as simple as that. And that's what nobody understands. That land is worth what it costs to replace. If I was asking a cent more than what it costs to replace, well, then I'm being greedy. We didn't ask for that. We asked replace what we have. And they said, no, we can't do that because of the uplift and because of this, because the Just Terms Act is fraud. It's a system that's fraud. It's a system that is causing depression sickness in families, upsetness, it's wrong. And it just needs to be changed for the people. I'm not saying the government to overpay for land, because it's taxpayers' money. We don't want that. But I think whether you got 5 acres in Orchard Hills or whether you've got a beachfront property at Bondi Beach, if it's going to get replaced, if it's going to get acquired, no matter what it is, you should be paid enough to replace that property with no questions asked. If anything, you should get more, not less. You cannot take something away from a personal home. Like my mother, we're nobodies out here. We can't fight the government, but all we want the people replace what that person has and get 5 local agents and see what it's worth to buy back in the area. But we couldn't do that under the Just Terms Act because of the laws and the uplift and this and that. But at the end of the day, we have to go to the local real estate agent and buy a property. That's all we want. And when we told the real estate agents what we've been offered, they laughed at us. Look, thank you for your support, and I'll cut it short there. The moral of the story is what people get taken away, they should be replaced, no matter what property, what shape, what form, and they shouldn't have to distress. And treat people with fairness, respect, okay? And that's Australia, all right? Where people went to war, people worked hard. Don't steal 1 cent from a resident. That's all I want to say, and thank you very much. And hopefully one day this can change and help people in the future so that we can live free and happily in a beautiful country that we live. God bless everyone, and thank you.
Thank you, Mr. Shibris.
Yeah, it's a bad time to interrupt, but I just have to go downstairs for our party room meeting. I'm sorry.
That's okay.
Thank you.
Luck with that. Thank you.
you.
Mr. Kohler.
Hello, everyone. My situation is similar in a way to the other parties, but also different. Myself and my brother purchased that property at Orchard Hills in 2011 after we'd worked together for about 10 years to save our money to get that deposit and to be able to buy that property. When we purchased that property, we done our investigation on the whole of Western Sydney and decided through all of our knowledge that that would be the best potential for us to put our money in to get a return in the future of potential development. And that's not hidden the fact. That's why it's got such good infrastructure and everything leading to it, and hence why now it's been chosen to put a metro line and a station through it. In September 2020, we got acquisition notice from the metro, and then by November we got an offer. The offer at that time was less than half than what the current market value was. I went and got 2 of my own independent valuations, and both of them come back at double of what that was. Double. How can that be? How can that possibly be that the valuation can be double of what I'm getting offered for my property and getting kicked out of? In June 2021, so 6 months later, basically, we get an offer the same as Vic, 70% more. 70% more. Now, if you just watch the media, what's happened in the last 12 months, property prices have gone up 20%, not 70%. Not 70%. Now, all current properties in Orchard Hills for sale right now at this point are $1 million an acre to buy. We're still not at that point. They're still not up in that point. They're trying any possible way to bring the value of our properties down. Now they're bringing in and trying to use a draft Cumberland Plain, which is not even it's not even fact yet, and cannot be used as town planners' advice. I've been told from multiple town planners that if you went to put a DA on that property, it would have to get approved because you cannot use a draft conservation plan of why you can knock something back. So how can they use that to devalue our properties? Like, it's not just fair or just terms that at all. And the biggest problem in this whole situation is that when Orchard Hills in particular has been earmarked for development for 30 years, right? But the reason it hasn't been developed already, it's because the unknown of what's happening with the station and what's known, or the unknown of what's happening with the airport. That's the only reason it hasn't been developed. But as a result of that, there's very, very little sales evidence, especially in the last 5 years, as there's been more and more talk about redevelopment of Orchard Hills. So there's no examples of how we can get actual fair price. And then when there is sales after the fact, we're not allowed to use them because of the Just Terms Act. So of the last recent 4 sales in Orchard Hills, 3 of them we're told that we cannot use because of the Just Terms Act, because the claim is that they're only got this uplift that they do have because of the announcement of the station. Also, one of the issues with the current Just Terms Act is that the way the town planning advice is taken, and in particular our case here in Orchard Hills, is that because there's been this lack of sales and lack of thing, there's not any evidence of urban planning. That's what the Metro's town planner has said. I've taken 2 town planners' advice from that and taken it to the Metro and showed them that that's incorrect, and that there's always been an urban growth plan for Orchard Hills in play. Yeah, it's just the whole Just Terms Act. It's just we've taken I've had my retirement. That's what I put all of my heart and soul in over the last 20 years of work and put it into that property, knowing that one day it'd be worth a lot of money and I'll be paid fairly from it. Instead, I get acquired and I can't even replace that. If you only need to do a search on realestate.com and have a look and see how many properties are one for sale in Orchard Hills. There's 1 or 2, and then what the price is. And they start at $1 million an acre, and they're no less than that. Anyone can do that. So how can they not be able to replace what they're taking away from me? It's just incredibly unfair, and mate, I thought the show The Castle was a joke, but this is played out right in front of me. And to a hardworking citizen like myself, I've worked for 20 years and paid tax and done everything correct the way that you're supposed to run your life and do the right thing as a citizen, but instead just get it taken away from me, my retirement taken away from me, and I've had to fight and continually try to fight to prove what this is worth, when all you need to do is do realestate.com and you can have a look straight away in 2 seconds.
Thank you, Mr.
That's
Collar.
all I have to say.
Thank you.
Thank you.
And thank you all for putting the sort of, the human face on the impact of the legislation and the process. I think just before I pop to the opposition to start questioning, I just wanted to check, Mr. and Mrs. Vella, did you say that your property had been acquired last Friday?
Yes, that's correct.
And that was through compulsory acquisition, not through negotiation?
Yes, that's correct. Through compulsory acquisition, yes.
Okay, thank you. I will start with Mr. Mookie.
Thank you, Chair. And can I firstly, again, thank all the residents, as the Chair said, for coming forward and telling your story. It's a very courageous thing to do. Can I just start with Mr. and Mrs. Vella, if that's possible, as well? Mr. Vella, you said that Mrs. Vella, you said that the property was acquired by a compulsory acquisition. Is that because you were unable to reach an agreed price with Sydney Metro?
Yes, that's correct.
And did that then go to the Valuer General for determination?
I believe that the Valuer General was already notified a couple of weeks ago, because that's just the process, how it all works. But yes, our next step in the process will be receiving a evaluation from the Valuer General. Yes.
And have you had any indication as to when you can expect you to receive that valuation?
Yes, there was actually a lot of talk that the Valuer General was delayed because there's a few things going on within their office or department. I actually gave the Valuer General's office a call a couple of weeks ago and spoke to one of the representatives. He said that they've already appointed a valuer and a town planner, and that he said if all goes well, we should have a draft by mid-October, mid to late October. We should have a draft valuation from the Valuer General.
But as of now, your home has been taken by Sydney Metro, that's correct?
That is correct.
And do you have to pay Sydney Metro rent?
At this stage, I believe not. It hasn't been it hasn't been told to us that we have to pay rent. I believe that we're staying here free of rent up until a certain date that has to be verified by our solicitors. But because our property was acquired last Friday, I think it was our solicitors today will be sending the Sydney Metro solicitors and asking the question of the exact finer details of us living at the property and if it's free rent or not, or just the finer details.
Can you tell us about what the impact has been of you losing your home on your family?
Yeah, it's been pretty hard.
Take your time.
So obviously, it's been very, very stressful for us. As we mentioned in our opening statement, we purchased this property and there was no inkling that this would be acquired. So we started renovations last year and we were almost complete, and then found out that our home would be compulsory acquired. So since then, our lives been revolving around this acquisition. A lot of time and expense has gone into this process. And, you know, as Vic said, we are not experts. This is all new for us. We've had to appoint solicitors, town planners, valuers, and that all comes with a very significant upfront cost.
Which, in saying that too, we were denied, I guess, upfront compensation cost to pay for solicitors. Now, I run a business myself. Now, it's the last 12 months has been very hard for us. Obviously, paying for our wedding, we had an overseas wedding that cancelled. We lost a lot of money over there with that. Now, in the last 12 months, business obviously has been hard. We've had people struggling to pay our bills, so we've been, I guess, struggling with having funds ourselves. And on top of that, to have our request for upfront funds be paid was, I guess, a kick in the stomach. You know, it's been hard for us to try and run a business, pay our workers, keep them in a job, and then pay for legal fees and valuation fees on top of that. And it's no fault of the solicitors and valuers because they've got to get paid, and we completely understand that. It's just that we were put in this position. So, you know, it just would have been a little bit of respect that I believe, yeah, like a portion or even just something to go to it. Look, but in saying that too, Sydney Metro have now offered us some sort of, I guess, compensation that we can claim, but obviously that was going to be from after the date of acquisition. So that will hopefully start the process today to see what the compensation will be. But up until this point now, we haven't received $1 from Sydney Metro at all, and we've outlaid a lot of money, which is obviously, like I said, the last 12 months with COVID, running business has been difficult, and you know, obviously, yeah, it's just been very hard for us.
Mr. Vella and Mr. Vizela, you've said that you have outlaid a lot of money. Can you give us an estimate as to what the cost has been so far?
Look, approximately, would you say between $80,000 and $100,000 or so? It's something. Look, don't hold me to the exact dollars. I haven't exactly worked out, but I'd say between $70,000 and $90,000 or so, maybe more. Like I'd rather just keep it on, I guess. Yeah, I'd rather keep it on the lean side, but I'll take that question on notice and get back to you guys with an exact answer.
And you said that this all took place soon after your wedding. Is that correct?
Correct. Yeah. Well, yes. Well, we were given the acquisition notice in September, just before we got married, a month before we got married last year. So it sort of put everything, just made it very hard for us at that time.
Mr. Chair, I will hand back shortly to my other colleagues, but Mr. Ziberis, are you also in a position to tell to us about what the impact has been on your family, and equally what costs you have had to incur as you've engaged with the process with Sydney Metro?
Oh, look, it's been challenging. Like I said, the offer was that the original. What creates the problem is the original offer was that low that there's no other way than to say, well, you were headed for death row. Well, we are nobodies out here. We're not millionaires. And when we got that first offer before Christmas, we didn't even tell our mother. That's how insulting it was. We did not tell our mother what the first offer is between the brothers and the sisters. And all we did since then is just fight and argue and phone calls to this and town planners to try and bring up the valuations and this and that. I mean, at the end of the day, something costs what it costs to replace it. It's as simple as that. I mean, we don't have to need 10 people in a room and 100 meetings and courts and that. It's very simple. If you have a block of land, that block of land costs what it costs to replace. When I ask Sydney Metro, all we want is to replace what we have. Well, you're on your own. That's your problem. I mean, they're living in an unreal world. I mean, you've got people trying to say what Orchard Hills land's worth. Orchard Hills land is worth what it costs to replace. So what should have happened in my eyes? My mother should be able to go down to the local real estate agent. It should be as simple as this. She's a 76-year-old widow. She goes down there to one of the local real estate agents, Jim Aiken, Lunny, whoever they are down there. She says, right, Jim, you're the biggest real estate agent in Penrith. Find me 5 acres in Orchard Hills. The next 5 acres are pretty equivalent. I mean, something that's equivalent, right? Let's be fair. As soon as you find something, okay, well, that's roughly what it's worth or what's on the market. But they haven't done that. They want to come up with these rules and these regulations. Oh, but you've got to drop it because it's a public purpose.
How much stress would it have saved you had Sydney Metro started the negotiations with a reasonable offer, as opposed to having to increase it by 73% over the course of negotiations? How much time would that have saved you?
It would have been enormous. Well, we've only now started looking at other properties in the last 4 weeks because of what's going on with this. You know, it's not right. Like our first face-to-face meeting was like 4 to 6 hours before that meeting. They come up, I mean, I don't know the numbers, I don't want to watch what I say, but they come up massively in the last 2 weeks before the end of the acquisition period. So, like, what's that thing, the pan? It was like 2 weeks before the pan was going to end when they come up with that massive gap. I mean, and it's still under change, but they do that on purpose.
By pan, do you mean property acquisition notice?
That's right. So my mother has done a deal, right? And she's shortchanged, but at the end of the day, she's 76 and we didn't want to go to court and prolong this stress, right? But at the end of the day, they test you. And what my argument is, don't test people. Don't put people through 3 or 6 month duration fight and bring up the valuation by 73%. Don't insult people. You know what I mean? Like, it's just that the stress is enormous for no reason. You all know roughly what it's worth. It's worth what it costs to roughly replace what you have. So what should happen? Sydney Metro should say, okay, what's it roughly worth to replace? And that's it. That's the moral of the story. Otherwise, people are going to lose out. It's as simple as that. There's not much more to say other than replace what you have. And if Sydney Metro think that we're ripping them off, let them go out and find the property. That's what I said to Sydney Metro. You go out, you find the property equivalent to my mother's, and when you find it, if you find it for $1 million, we'll give you my mother's for $1 million. If you've got to spend 7, 8, 10 million, well, you give my mother 7, 8, 10 million dollars. I've told that to Sydney Metro, but they say they can't do that because of whatever the laws are. So,
Mr. Kohler, can I ask you the same question? What has the impact of this acquisition been on you and your brother, and how much cost have you had to incur so far as you engage with Sydney Metro? You're on mute, Mr. Kohler.
Like I said, it's had a very detrimental effect on myself and my brother because we'd invested all our life savings into that property and to pay it off to know that one day we would have that potential development value for that property, and hence why we bought it there. And exactly what Vic was saying is that they can't give me back what they're taking off me, and they're not even giving me enough money to be able to do that. And then the kick in the guts is when you get that initial offer, it's just a game. But they're playing a negotiation game, and if you're not wise enough to say no with the first offer or to fight them, then you're going to get half the money than what the actual value of the property is. and then how much I've spent. I've probably spent more than $80,000 because I wanted multiple parts of evidence, because I was never going to, once I received that first offer, I was so upset that I got multiple town plan offers, multiple town planning advice, multiple valuations on my property. Each time you do this, it's $5,000 to $10,000 each time. I'll be in excess of $80,000 I've spent now and had no compensation back as yet as well.
Chair, I might pause there and just ask if my colleagues have any questions if they
I might ask a couple. So there's a few things here. I think from your testimony, it's very clear that you're not asking for something in addition to what you have now. You just want to be made whole. And I think that has come through really clearly. I just wanted to ask, in terms of the support that you were given, clearly we have Sydney Metro, who has a lot of experience in acquiring property. They have people dedicated to that process. And then we have yourselves. There's a real power imbalance there, isn't there, in that negotiation? Did you get any sort of assistance in terms of, you know, the legal or the financial advice to be able to have that negotiation on a more level footing?
Is that towards me, that question?
I'll start with Mr. Vella, and then I'll come back to you, Mr. Kohler.
So in terms of what was the word which you said?
Like assistance.
In terms of assistance, financially, obviously not. We were declined of any financial assistance. Like I said, I believe I think they have offered some sort of assistance now up until like after the property was acquired. In terms of emotional assistance and stuff like that, they've got a representative that is meant to be our personal you can speak as well, personal relationship manager. I guess, look, he probably does try his best. The reason why it probably doesn't work so well is that it's not his job to know all the technical side of the acquisition. Now, to help us get through it, we wanted to know why property was being acquired, what the valuation was going to be, how it was going to be fair. Now, that person, by no fault of his own, he couldn't help us with that. So us ringing him up, it didn't help us, because when we were speaking to this representative, he didn't have the answers for us, you know, and it's by no fault of his own as well. So, and by luck, the same representative that was assigned to us by Sydney Metro was actually the same representative that told us our property wouldn't be acquired 3 months before. So, to be completely honest, I lost complete trust in that representative, because for the same representative to give me assurance that the property wouldn't be acquired, then for him to be assigned as our relationship manager, I lost complete trust in him. And look, like I said, it's by no fault of his own. It's not a personal attack on him. He's a really nice guy, but you know, it didn't help us at all. Like we had many sleepless nights, and yeah, I don't think it was
So this is a relationship manager appointed by Sydney Metro. Is that correct?
Yes.
Who is okay, but they're not on your side. They're sort of sitting in the middle between you.
Oh, correct. Well, look, I wouldn't say sitting in the middle. I'd say definitely on more of their side, but he's the one that's in between us and the Metro. And yeah, he was the one that I guess we were meant to go to and speak to about, I guess, our concerns and stuff like that. Yes.
So if you want to get any sort of power in terms of being able to understand the process, having somebody who represents you, who can actually, I guess, have the same sort of level of knowledge and experience as Sydney Metro, you'd be looking at appointing an external person for that, which is how you get into the costs that you talk about. Yeah. Exactly
right. Yes. And obviously we're not experienced in any of this. So for us to try and make assumptions on what we've been given, it's just like, that's what I guess we paid our solicitors for and our valuers for. That's their job. And obviously we're not, I guess, experienced. We're not experts in this field. So for us to try and comprehend it, like, it was hard enough for us to read through the thousands of pages of the EIS and multiple ASs for projects, as in like the Western Sydney Airport line and the Metro West line. That was hard enough for us to spend time reading all that, going through all that, and to realise what was actually going on here. And then, let alone trying to deal with the exact details of the acquisition and the process. Like, I guess that was the reason for our solicitors. They've done a great job of informing us to this point in time. But obviously, it costs money, and the hardest, like another hard thing, obviously, was that we weren't. I guess they didn't agree to give us the upfront costs to cover those fees.
So when you offered Sydney Metro a lease over your property on the basis that they were only going to use it for construction anyway, and they could perhaps give it back to you at the end,
Correct.
how
Yep.
was that offer made, and was it made on specific terms? Did you put up a particular price?
No, so what we didn't get to that. So basically, that offer was made through our solicitors, because we came to the fact that the property, Sydney Metro sort of confirmed that the property would not be affected on the surface of the land post-construction. Then our solicitor made an offer to Sydney Metro for the construction lease. There was no money was mentioned of what the amount for the lease would be at all, because it didn't get to that. Pretty much straight away, they came back and said, no, we're not accepting that lease. We're acquiring the property as a freehold, and that's it. The discussion did not go any further.
Thank you.
And, yeah.
Sorry, I'll go to Mr. Franklin.
Just one question, if I may, Chair. We've heard evidence from you today, and thank you very much for being here, that one property was revalued upwards by 73% and one by 70%. My question is, what was the justification? That's extraordinary to me. What was the justification that they used in such a massive disparity? Like they had to say for some reason the price had jumped by that much. What did they use any justification at all? Can I start with Mr. Kohler?
In my case, my second offer from them was made in conversation to my solicitor, not a formal offer. So I don't have any justification of that, because I denied the offer straight away. So I never got to that stage where they would provide that to me. So I can't answer that question. I can't give you that answer.
Thank you. Mr. Vella?
Look, I believe, I think there may have been a conversation that when I questioned the uplift in the valuation from Sydney Metro, that I think they said that they took into account, they may have taken into account some evidence of a recent sale. But like I said, it was a very vague conversation, because we obviously didn't accept the offer. It didn't go any further than that, but it was a shock to us that they came to us, obviously, with our first offer. Then they came to us probably, look, don't quote me, a couple months later, with another offer saying that the property did not go up in value. And this was, I believe, early 6 months later, saying it didn't go up in any value. Then after that, maybe another 4 to 8 weeks, I'll take that on notice and I'll get back the exact time. Then it jumped up a substantial amount, where I couldn't understand that in 6 months it didn't go up in value. Then in 4 weeks or 6 weeks or 8 weeks, then it jumped up dramatically. I couldn't understand that as well. But like I said, I believe that a sale came up that they were able to possibly use in some sort of shape or form.
Thank you.
We are running out of time, but Mr. Graham, did you want to jump in with a question?
I've just had one question for Mr. and Mrs. Vella. You talked about the fact that much more land has been acquired than was needed, or certainly much more land than has been acquired for possibly 9 stations on another line. When you've raised that issue, why is so much land required here, if not just for the station, given you are concerned that it's essentially a development play by the government agency? Have you been given any answer or any satisfactory answer?
Our answer was basically just Terms Act. That's basically, they basically said, well, we've spoke to contractors and this is what land's required. I'm lost for words, and basically, like, we still can't understand why. Like, still to this point, we don't know why. It was just basically, we're taking your land, It's under the Just Terms Act, but we have the power to do it, and that's what we're doing. There was no real reason for it. Like obviously, it just does not make sense. 65 acres for one station, and I guess the construction of the line, which is mostly tunneled through under our property. It's a tunnel anyway. But then obviously they can go and build the Metro West line in a more densely populated area, I may say as well, where Orchard Hills, where 5-acre rural properties, there's a lot less going on here than what there is, I guess, in the Metro West line as well. So how can you go and build 9 stations and the whole line in approximately 40 acres, but then one station is only 65? It does not make sense whatsoever. Like not, and then like for us to get that clarification from City Metro, for them just to say, it's the Just Terms Act, we're going to take it. Our solicitors bring it up as well, and questioned them on it, but it's basically got the response back. We're acquiring the property as a freehold interest as per the Just Terms Act, and that's it. And they've got the power to, I believe they've got the power to under the Just Terms Act. So it needs to change. Something has to change with the Just Terms Act.
Right. Thank you.
Thanks.
Thank you. Unfortunately, we have run out of time, but I think that this has been an incredibly useful session, and thank you so much for coming and talking to us and giving us the benefit of hearing about your experiences. There were no questions taken on notice, but to the extent we have supplementary questions for you, the committee secretariat will be in touch, and you'll have 21 days to get back to us. But that concludes this session. We will now have a 10-minute break and come back with our next set of witnesses. Thank you very much. Hello, I think we are back. Welcome to our next set of witnesses. It is very good to see you. I will start with Mrs. Vella, if I could. If you could state your name and position and then swear either an oath or affirmation.
Good morning, everyone. My name is Christine Vella. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God. I am also a resident of Orchard Hills.
Thank you. And I'm worried I'm going to pronounce this wrong. Mr. Grimer, could I ask you to state your name, position, and swear either the oath or the affirmation?
Yeah, Samuel Grimer. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you. And Mrs. Grimer.
Teresa Grimer.
It's Teresa Grimer. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you to all of you. If we could start by inviting each of you to make a short opening statement, if you could try and keep it to a few minutes so that we have time for questions, that would be fantastic. And I'll start with you again, Mrs. Vella.
Good morning all. My name is Christine Vella and my husband and I live together with our 3 children in Orchard Hills. We have lived here for 12 years and have built our lives within and around our community. We had no plans to move, and when we purchased our home, it was free from any encumbrances or transport proposals. We are not against infrastructure. I have previously submitted a submission that was written in July outlining our concerns in regards to the acquisition process. Our family home has since been acquired last Friday. I'm happy to give evidence and answer in detail any questions you as the committee may have in regards to the acquisition of our home or any problematic issues that have arisen from it. Thank you to all.
Thank you. Mr. and Mrs. Grimer.
Good morning. My name is Teresa Grimer and I'm here with my husband, Sam Grimer. We have lived in Orchard Hills for 20 years and we have 2 22-year-old boys still living at home. Metro's initial phone call was September the 11th, 2020. We were not at home, we were at work, and they made a call to our mobile. You cannot begin to imagine what that phone call did to us in the weeks and months ahead. The unnecessary stress associated with this whole situation and financial stress has made it very difficult, even harder due to COVID. From that day, we have been living in a nightmare with continuous stress to us, our family, and my business, which we can't get back. Sam is a 3rd-generation farmer, and we live 15 minutes away from his mother's farm where we run our market garden business. We have situated our home and business near both. Sam wakes up before midnight 3 days a week. If we don't find a property close by, it will add additional travel time, which will affect his health due to less sleep. We are being disadvantaged of no fault of our own. Because of rising property prices in New South Wales, it has been very difficult to find a property like ours. Properties in Orchard Hills are difficult to find. It is a tight-held suburb. We are 1 minute to the M4 freeway, major hospitals, shopping centres, universities, and 3 train stations in a 5-kilometre radius. We just want to relocate nearby. It has been a constant fight to get a correct valuation that reflects our property from the Metro. Their first initial valuation was dismal. The offer was so low, we think it was a negotiation ploy to beat us down and make us accept with no regard to the true value of our property. All we want is to replace what we have and stay in our area. We are a hardworking family. We are proud people and very proud of our home. It was to be our forever home. Countless hours, money and effort have gone into our property. Our initial meeting with Metro was face-to-face and we thought that they were sympathetic to us, but afterwards it was like we didn't matter. Every offer we made to them was refused and they did not want to negotiate. It has been a heart-wrenching process. We've been professional and courteous and treated the Metro with respect all the way through to this process. Every offer we made to them was refused and they did not want to negotiate. This process is not a negotiation. We don't even know how we got to this stage of going to the Valuer General. What's the point to get a valuer and a town planner, because everything that's been presented to them has been ignored and rejected. The negotiation should be 2 parties coming together to resolve the issue, but the Metro were not willing to negotiate with us. If we don't agree to their offer, we're off to the Valuer General. The Metro are relying on a draft plan to devalue our property, and now we've been informed that the draft plan may not even go ahead. 2 weeks before the plan period ended, Metro brought up a biodiversity issue and it has been heavily discarded over 3 trees on our property. It was a real kick in the guts. This biodiversity is still in draft form and is not yet zoned. How can something that is not zoned be a reason to heavily discount our property? How can we not be able to use recent sales in our area to its full capacity, but must use it at a discounted rate because of the public purpose, and then something that is zoned and is in draft form be used and to have it discounted? It does not make any sense. They keep mentioning we must follow the Just Terms Act of 1991. It is a law that is 30 years old. It is outdated and it constrains us from everything. It does not work in these current times on acreage properties. Our valuer has his hands tied. We cannot believe that the Metro are acquiring 65 acres of land to build one train station when Westmead was built on 4 acres. What is the justification of them acquiring that much land? It is totally wrong, and they are pushing us out of our home. Thank you.
Thank you so much for those opening statements and for being here today and sharing your experience. I will start with the opposition. Is that you, Mr. Mookie?
Yeah, I'm happy to kick off. Thank you, Chair. And again, can I thank the witnesses for making your time available to us this morning and for being so candid. Can I just start by just getting a bit of an appreciation as to where you are respectively up to in the process? Mrs. Vella, you said your property was acquired on Friday, is that correct?
That is correct.
And was that by agreement?
It was by agreement.
And how long did it take you to reach that agreement?
It right up until the agreement was signed last, not this Monday, the Monday before.
And it started in September last year?
Yeah, so we received an acquisition notice on the 11th of September. We actually got news for the proposal back in 26th of March 2018 for a different version of the line. My husband and I and our family have waited for 3.5 years. We waited 2.5 years for the gazetted line, and then we've been in this acquisition process for the last year.
So in total, it's been 3 or 4 years of your life?
Yeah, 3.5 years of our life.
Yeah. And insofar as you reached an agreement, are you in a position to shed light as to the difference between Sydney Metro's first position and I guess the position you agreed? Did it go up or down?
I haven't worked out the exact percentage, but it is dramatically higher. I will say it's still not like for like. You still, I can say, I can speak on our own position that we will be financially worse off from what we began with, and that under the terms of the legislation that we've had to endure, I can't see how anyone would be able to, at the very least financially, be in the same position that what they began with.
Just on that point, I understand that you don't have the exact difference. If you don't mind taking on notice the difference between first position and last position, but the other witnesses earlier this morning made the point that in one case it was a 70% variation, a 70% increase on Sydney Metro's first offer. Is that similar to what you've experienced?
It would be a similar percentage. It wouldn't be far off. Yeah. Like I said, I don't know exactly. I would have to go check my figures, but it would be very close.
And you made the point that you don't think it's like for like. Does that mean you don't think that that would allow you and your family to effectively be reinstated in Orchard Hills?
Not in the same. What we have now, we couldn't replace on what we've agreed upon.
And Mrs. Vella, in the last year, just quickly, how much costs have you had to incur on lawyers and town planners and valuers?
In excess of 100,000.
And did you get any of that compensated?
Yes, I did within our agreement.
Sure. Can I just ask, talk to Mrs. and Mr. Grima as well? You are yet to reach a position with Sydney Metro, is that correct?
Correct.
That's correct.
Have they issued you a property acquisition notice?
Yes, they have with our solicitor.
And have they then now taken possession of your property? Do they own it? Or how far away are you from them owning the property?
Well, I believe it was last Friday that it was gazetted, so I would think so.
Friday, yeah. And you're off to the Valuer General, are you?
Yes, that's correct.
Yes.
And is that because you haven't been able to reach an agreement with Sydney Metro?
That's correct.
And how many offers has Sydney Metro put to you?
3.
And are you also in a position to shed light as to whether there's been dramatic variations in their position?
From a ridiculous offer, then just before a meeting we received the higher offer. There was an offer in between that, but then we got the higher offer.
I'm not quite sure the percentage of it, but I can get back to you with that.
But as it is, it still wouldn't permit you to reinstate yourself into the suburb and certainly not close to your flowers business. That's correct, Mr. Graham.
There's no chance.
Yeah.
Not with what we have invested in our property here.
And is that the reason why you're yet to be able to reach agreement with Sydney Metro?
Well, we were willing to agree to negotiate. We've attempted to negotiate, but they were just stuck on that number, and they wouldn't back and forward, and nothing's really happened. So next thing you knew, we were in front of the VG, the Valuer General.
How much costs have you incurred so far in this process?
It's over the 100,000 already.
And how have you been able to pay for that?
Well,
It's just getting onto our loan.
yeah, we've had to actually use our loan to do that.
We've been clearing off our line of credit.
Right. Just can you describe what you run a business in the area as well? Is that correct? I hear you correctly?
Got a market garden at Horsey Park.
Yeah. And you sell what, flowers at Flemington, do you? Or?
No, we're vegetable growers. So
Right.
we grow vegetables and sell vegetables in Flemington markets, and also at North Sydney markets and a few growers markets that we do.
So can you tell us what has the impact been of this whole process on both your family and your business for the last year?
It's turned my family inside out. It's emotionally stressful. And when you feel like you're going forward with Metro, within a few days or a week, we're back in stage one again. I feel like we're cattle in a yard, and we've been pushed in a big yard and pushed forward into the crush. Nothing more. I feel that we're going to, and we haven't actually come to some negotiation.
They're not willing to negotiate.
They're throwing numbers at us, and my valuer had put a fair valuation, and we're there and they're there, and we've tried to move now to clarify everything, but they just stuck to their valuation.
Can I ask?
It wasn't really a negotiation.
No, it wasn't.
In our case, I feel.
Can I ask what effort has been made by Sydney Metro to make the process easier on you?
We went everything through our valuer and our solicitor. So because of the emotional stress and everything, we found it easier not to deal with Metro directly, except for a meeting. We'd have a meeting with them, and when it was necessary to have a meeting. At the meetings, we felt like we were progressing when we were in Metro. But as I said before, as soon as that meeting's finished and the things, it came back to square one. So there was no steps forward, I feel. It was just one step forward and then two steps back. And it's not like we weren't willing to meet somewhere along the line and try and resolve the situation. And then we were hit with that biodiversity, which was even more a kick in the guts.
Definitely.
So to me, why should I have a lump in my stomach and sleepless nights, and I get up 3 days a week to go to Flemington to feed people and have to deal with this? And it's not anything of my fault. You know what I mean? And it's turned my, it's turned us upside down. We've got to go and try and do something so we can forget about these things, so we can continue working and feeding people. So I don't understand where there's a negotiation. There isn't. And it's not like I wasn't willing to try to get everything out. And I said to them when they came in to walk to my house, I said, I need to resolve this to get my family on track, because I knew it would bring my family down, because it brings me down, because we're emotional. And I negotiate with people every day in the market. And what I feel that was not a negotiation. So how can that be fair? A negotiation is two parties coming together and resolving the situation so both are happy and walk away happy.
Wasn't the case.
And it wasn't in the case in our case. I feel that they just stuck to their guns, and how they came to a valuation on the biodiversity, I do not know. How they come to that figure. They dropped it down to that much. When my neighbour, a fence between us, put her on the market, it's fully
Maybe
or
give it-
proposed anyway. It's proposed, and then I've got 3 trees, and they haven't discounted me that much. You know what I
So
mean?
keep it nuts.
And that was the final straw. And I just put my hands up and I thought, all these 40 years that me and Theresa have been getting up at midnight and going to the growers market and feeding people I'm going backwards. And we're people from the land. These people, we're all people that came from farms and the land is not just land. The house, I can build the house. I can build a home, but you can't take my land. That's what feeds me. Fed my family. My father was a farmer, and that land's more to me than just money. That's something I strive for all my life. You know what I mean? Trying to get somewhere, and then I got to put up with this. That's wrong. And these people, the residents that we have here around us, are in the same situation, and they've been put through more and more stress. You know, and I feel for them too, as much as I feel for myself, because I know, and these people have been longer than me. You know, and how can that be? That's a negotiation. Anyway.
Can I just ask, did Metro ever identify a reason why they particularly wanted your land?
They said they needed it for earthworks.
At any point, did they suggest or did you suggest that maybe they should lease it and give it back?
Oh, look, I would lease it to them, of course I would. But I mean, I didn't put that in writing, no.
Yeah.
But I would lease it to them.
Mrs. Vella, did Metro ever identify the reasons why they needed your land?
Yeah, we were identified in the EIS in October for laydown and material handling. We then tried to negotiate construction leases in a variety of proposals through our lawyers, which we were all knocked back on. With a meeting with Sydney Metro earlier this year, we did push the fact that there was no permanent structures on my husband Jason and my property. They did suggest that maybe, quite possibly, they would put the station car park on our house, but that is yet to be determined, and there was no evidence to suggest that at that point. But they did then tell us that no construction leases would be offered over any of the properties in Orchard Hills.
Did they ever specify a reason why they would refuse to offer construction leases?
Not an adequate one, no.
Did they, given that they are acquiring 65 hectares, where I think the equivalent in Westmead is 1.5, what do you really think the reason is why they want so much land?
I can't, it would be an assumption why I would.
What do you assume?
But I assume that it is heavily advertised that it will become a mixed use precinct, and there's documents to suggest and words to suggest that it will be a developed precinct around the station. I know that it has been done before on the Northwest Line, and I think it's the Transport Amendment Bill of 2018, which gives Sydney Metro the right to develop the excess land around stations. As to date, I believe that this station is the biggest construction site that has been used by Sydney Metro. It is in excess of 65 acres, and the reason why we do bring up Westmead Station so much is because, on par with Westmead Station, it's a very similar construction methodology as per their EIS statements on both lines. There is also a higher number of workers and excavated spoil on the Westmead site as opposed to the Orchard Hill site. So it is. I still haven't heard an adequate reason why they are acquiring so much land. And I think what gets us as well is that this has, as you've heard from the Grimers, turned our lives upside down. I mean, it has ripped this whole community to shreds. I have 3 children and my husband who have suffered physically and emotionally for the last 3.5 years due to this line. But the New South Wales government does advertise that they minimise acquisitions in every effort that they do, and I can't reason how that has been done.
My final question before I pass to others is, did either of you have the opportunity to either talk directly with the head of Metro at any point in time, or for that matter, the Minister or anyone else from Transport for New South Wales or the government who might be able to step in and at least ensure that a fair process was being followed?
Over the course of the last 3.5 years, I've spoken to many government representatives, many people from First Transport for New South Wales. Tanya Davies has been advocating on our behalf, as well has Jim Wilson from 2GB, and we have also spoken at times with various people from Sydney Metro.
Did you have a chance? Yep, sorry, John. Yeah.
I was just going to follow that point you made about the community, because you've each spoken very clearly about the impact this has had on you or your families. But the point a range of you have made is, look, it's very difficult for us to buy back into this area. It's a relatively close-knit community. What's it actually done to the community of Orchard Hill, who've been there for quite some time?
It's to watch the people around us suffer through depression, anxiety. A lot of us aren't sleeping. A lot of us are elderly. I can think of one in particular that's lived here for 50 years. He's been in and out of hospital. His health has deteriorated dramatically. He's 76 years old. He's married. The toll that it's taken, particularly on their lives health-wise, I hope it hasn't, but I can't see how it hasn't done permanent damage to his health. I mean, they're just one for the worry and stress. It's a flow-on ripple effect, and like I said, I can see it in my children, which breaks my heart. But to try and console and to witness this and live in it and be immersed in it, particularly for the last year, has been horrendous.
Yeah, Mr. and Mrs. Grimer?
Yes, I would have to agree with Christine. It's definitely taken a toll on all of us. We're a tight-knit community, and it's just breaking apart something that we've sort of lived here for so many years. It's made it very difficult and stressful.
Yeah, it's just unbelievable. Just, I feel that it shouldn't have to be this stressful. It should be a process that flows along. And it feels like, to me, Metro have been coming up with one thing after another and prolonging the whole situation. And it's stretching on and does come up with something different, like the biodiversity now, just to kick you in the guts a bit more. And well, we're losing not only our home and our property and that, we're losing our friends. We're not like, if I need something across the road, I'll just duck across the road and you can fix it for me as a welder or Jason, you know what I mean? We know him. We've known him for 20 years. We're not living next,
Yeah, no, exactly. Thank you for your evidence today.
Could I ask on that? I think you've made it clear that you're not anti-development, you're not anti-infrastructure. This is about, I guess, doing this better. It's very unfortunate to hear your experience and particularly the stress that it's created for you. If we were to design a better process, what would it look like? What could be done better?
It's hard to say. Look, if you're talking about farming, I can tell you, the system is in the government's hands, but I feel something that a person doesn't bring onto themselves and gets put onto them should flow, and it should be an easier process where it's not a matter of pushing that person down to where he has to cry for his money for the property that he's worked so hard for. You know what I mean? It feels to me not a negotiation. It feels to me, this is what you've got and this is what you're going to get. And this is because the Just Terms Act pushes them towards it. So you can get the best valuer in the land. Yes, Metro said, oh, you can get your own valuer, you get your own town planner, and so on and so forth. But if you tie his hands up, because he can only value the property on rural or on recent sales, fair enough. But the recent sales have shown in New South Wales, if not in all of Australia, that the property market has been going up. So we're not in that same situation where the valuations are that they've just gone silly. And they say, well, it's because of the public purpose. But it's not necessarily because of the public purpose, because if it was just of the public purpose, it would be everywhere. But in the city, they're breaking records. You know, even here in the Western, for a housing block, the agents are saying, I've got my niece, she's looking for a house. The agents are saying the property owner, we're quoting the property at a certain amount of price, and they're getting 200 plus more. And we're just staying with our jaws dropped. So how can we then keep on taking a discount, and we can't use the property next door at a discounted rate? But then it's sold for so much money that then my little biodiversity, 3 trees that I left for the cows for a shade, is a ridiculous amount valuation on it. And then how can you come to terms with that? Where did they get that number? That's what that tells me, you know.
So Mrs. Vella, could you respond to that question as well? I mean, I guess there's the price issue, but what else could be done in terms of the process?
We found through this process, so if I can start at the beginning, if you don't mind, when it was first proposed, Transport for New South Wales, we had a submission period for 6 weeks. In that time, we submitted 2 alternative paths for this line, which minimised home acquisitions. We had a total of 986 signatures submitted for those proposals. In December of 2018, we met with Transport for New South Wales, who stated that they were viable options, and at least one of them, which would have seen the line run alongside the M9 and the freight line in government land, would be submitted to the government, upon which the government would vote on. Now, obviously, the government didn't vote in that favour, but there was a line there that didn't affect as many people as what it did now. So on that point, I'd like to say that government should be held accountable for not minimising home acquisitions. These are family homes and businesses. People have spent their lives. They've spent their lives working towards this. I mean, my husband, we're only one situation, but my husband and I obviously sacrificed a lot to live where we live and to own our own place and give our kids everything that we could, but also for my neighbours, ultimately it's their superannuation as well. When you're 76 years old and someone rips that in half, it's very scary and terrifying. And so everybody has a story, and everybody's home should be treated with respect. If the government can minimise acquisitions and they're not, then they should be held accountable. That should be number one. Number two, going through this process, like we said, the construction footprint of Orchard Hills is absolutely massive. We don't have any answers, any adequate answers as to why that is so. There should be regulations in relation to that. If there's not a real, if there isn't a necessary reason to take someone's home. You shouldn't be. There needs to be accountability held for that. And as for the uplift, the main problem we have in establishing our evaluation of our home is the legislation. I feel, and my husband feels, and I think it's a general feel of the community, is that the legislation is heavily weighted towards the government. It is not until you get into the process, and it has been a huge learning curve. My husband and I, a year ago, thought we were well aware of the process. We had met many times with Transport for New South Wales. We felt we were well schooled in compulsory acquisition and the process to come, but we weren't. At every turn, we were hit with unexpected legislation, which made it very, very difficult to establish even a relatively okay valuation of our property. And it's good enough to say that $100,000 is a lot of money, but $100,000 is no good to me if it can't buy me what I have. And as soon as government representatives knock on your door, you have instantaneously lost your home and removed from your area, because there is no way that you can establish a proper rate. After that happens, because the public purpose has been advertised, it can be argued in a court of law that a percentage needs to be deducted from every sale that happens from therein. And you will always be behind. There is nothing that can be argued that you can use a like-for-like property for your own.
Could I ask, why did you then reach an agreement with Sydney Metro prior to the compulsory acquisition? What determined that decision?
My husband and I reached an agreement with Sydney Metro purely for the fact that we did not want to proceed to court. That is the reason why. We have suffered greatly. Our family has suffered, our marriage has suffered, our children have suffered, and we felt that we did not want to take the risk going to court.
Is there some relief now with having had the process effectively end? Do you know how much money you've got to be able to look for another place?
There is some relief in that respect. There's some respite. However, we will, as I said earlier, we are not financially better off. I don't want that to. It was a decision made for with a risk factor taken into account and also a mental health factor taken into account. There are numerous reasons, and I can't say, like I said, I don't think anybody. I can only speak for myself, but we are not financially better off. We're in the same position as what we began with.
Will you be able to now find another property in the area?
We are actively trying, but like I said, it will be to our detriment. If we happen to find another property in the area, we will be significantly worse off for it.
Thank you.
Can I just going back to Mr. and Mrs. Grimer. Mr. Grimer, you made repeated references to the issue of the biodiversity. Just so I can properly understand that, you have 3 trees on your property and they discounted the value of the compensation as a result. Is that basically it?
That's correct.
3 trees in the biodiversity.
Can you and you kept these trees, as you said, to provide shade to your animals. Is that correct?
Yeah.
We had cattle on.
We had cattle and we thought we'd leave them there. And
can you just tell me how much was your property discounted for? What was the range?
Well, from say 80, from 200 down to 80.
That's correct.
Sorry, they discounted your value by $120,000?
That's correct.
So $40,000 a tree.
Sorry?
No, but they apparently it's not just the trees. It's a chunk of land. I don't know if it's the height of the tree the amount of code that
Shade.
tree produces as well.
So you would have been better off just land clearing, basically.
Well, 100%.
Yeah.
I always thought, you know, I'd do the right thing, and you know, they didn't bother me at the time, and I wouldn't, you know, they look good.
And you made the point that there's no part of the Just Terms Act that requires them to do that. It was a discretionary choice of them to include the biodiversity on your property. Is that correct?
Yes, that's correct.
So do you feel like you're being punished because you were a proper land steward?
It was the last nail in the coffin, as far as I'm concerned. It was just too much money, and we still tried to negotiate down, even though with that. But if I compare it to next door, she put it on the market. It's fully
Heavily timbered.
Hasn't got the house that we haven't got, but it sold for over 250.
Square metre.
So
our biodiversity is worth 80.
Right.
That's why I can't come to the number, how they got to that number.
So you might have the Western Sydney's most expensive trees, really, is what you're telling us.
Oh, yeah.
Yeah.
Yeah, I might build a house on it.
It just look.
It's ridiculous.
I
Doesn't
don't
make
want
any
to point too much, but you did point out to Metro that this seemed like an absurd decision on their part, did you not?
Well, we didn't actually.
Our
Our
solicitor.
solicitor was
on your behalf.
Yeah, we were trying to negotiate, and yeah, we tried to say that it's an absurd thing, and they were saying, well, they're talking about it because it's still in draft form, the biodiversity. So we feel like things were happening in that situation where the government bodies were talking about whether they can actually do that.
Tony Davies has been trying to help us along with that as well.
And so my solicitor gave him a couple of different down offers. So we'll come down from our initial valuers thing, and next we were at the VG. We got a call from my solicitor, got a call from VG and said we were overlooked, and I want to continue on with that situation. So instead of resolving it and trying to get my family back on track, and all this headaches and stress, we've actually added to our sleepless nights, and
Yeah,
so
because
it's a never-ending story. So I can understand why people are actually had enough and just want to get on with their life.
So how long do you foresee the Valuer General process to take for your land? Have you had any indication as to how long that's going to take?
No, not quite sure.
We don't know.
We're just waiting for our solicitor to speak with their representative to organise another valuation for them to come out.
See, we feel like it's all starting again. So this whole year's been just upside down, and now it's starting again. Our nightmare's starting again.
We've got to go through the process
So,
again.
I'm just trying to keep the family positive, and I haven't been sort of saying too much, you know, it'll work itself out, and that's why we put everything through the solicitor and through our valuer, because you want to try and get you're zoned away from it for a while and just have peace in your life. You know what I mean? And that's it. And I'm sure why other people have signed and just to try to continue on, because it's just a never-ending process. And it, like I said, it feels like you're going forward when you have a meeting, and then something else comes up, and it's ridiculous.
Do you sense that Sydney Metro have negotiated with you in good faith?
I feel there's a process. I'm not sure about good faith or not. No, I don't know, but I don't feel that it's a negotiating system. So you can't, if one party's willing to negotiate and the other party is holding to its gun, well, it's not going to happen, is it? It's not going to. You can't meet anyway.
That's what's
and I feel that I didn't bring this onto my family. You know, the Metro and the government bring this onto my family, and I've got to deal with something that I've never, you know, I can deal with a lot of things.
It's no fault of my own.
I can handle a lot of things and I'll push forward. But
At some point, right.
even the financial side of things, it's like, how would you do it if you didn't have a way to get the money? Because it's already cost me over 100,000. You know, I worry every time I get a bill. I need to run my business. I need to feed my family. Instead of my loan going down, my loan's going up. You know what I mean?
That's it for me, Chair.
Thank you. I think just coming back to that question, I guess, of negotiation and whether in fact you can have a negotiation when there's such a power imbalance. What could be done, do you think, to create a more level playing field for that sort of negotiation? Would it be upfront sort of compensation, or you know, a payment for your legal fees? Or
look, I think the process. Look, I mean, I think the process would have been finished 6 months ago with a lot of the residents. If you put me there, I would have negotiated 100 times better. But you got to be fair, and you got to say, look, you're going to find some people that are hard-headed, and they're going to want a silly price. Fair enough. Well, then we'll go through the system then. But if you're willing to negotiate, and the two parties are coming together, well, negotiate with these people. It's not like we're saying, no, we don't want to negotiate with you. We want, you don't come with a silly price. I mean, I could have told my value with a price in the sky, like they priced theirs very low. So I don't understand how they come to that valuation in the first place. So it's a process, I suppose, but maybe it's their process. I don't know. But I think you have to be realistic, you know, and look at what's happening out there.
As you say, this is something that's been done to you without any sort of agency on your behalf. So if the Just Terms Act was instead, I guess, directed towards you not being in a worse off position after the acquisition, do you think that would create a better process?
Yes.
100%. I feel you, like I said, why can't we have a system where they do have some? I think overseas, where the two parties get together in the benefit of both. So the government goes forward and the landowner goes forward. And then the community are happy because we can get infrastructure done. But not when I didn't get the land given to me. I didn't drop from the sky and was given to us. This land was worked hard and earned hard by hands, and the same with the other people, because we like people that want to live on property. If we wanted to live in Manly in a unit, well, that's fair enough. But we're not. We didn't come out here for a metro to come through or thinking that we're going to get rich out of it. But at the moment, land is harder to get. The land that you've got in the Sydney Basin, for example. And that's the whole issue. It's a totally different thing. If I'm in a house block, well, I can try and find a house similar to mine in a residential area. But it's not so simple to go out there and buy land. And you say, well, don't buy land. Buy 2.5 acres. But why would I buy 2.5 acres when I want 5? I'm a farmer, and these people need that. You know, that's what we need.
Being disadvantaged all the way through.
It's a disadvantaged system. And like Christine said, the Just Terms Act is heavily favoured towards the government. And yes, you can get your own valuer, but his hands are tied to a degree. But if their valuer and your valuer are totally do different price ranges, okay, it's here and it's here. Well, where is it? Where in that gap? Where do we get? It hasn't budged from there. We've budged, but they haven't budged.
Thank you. Unfortunately, we are out of time. Thank you again so much for coming and for putting your stories on the record. It's really incredibly helpful for the committee, but also hopefully for those viewing and reading the transcript of this session to sort of see the very human impact that the process can have. So thank you very much for that. We're going to take a break until 11:30, and then we'll be back with witnesses from Sydney Metro.
Thank you.
Thank you.
Thank you, Deborah.
Thank you for having. Thank you.
Welcome back. We've just got our witnesses joining. Mr. Regan, can you hear me? Let's try again. Mr. Regan, can you hear me?
I can, yes. Good morning.
Good morning. And Ms. McPhee?
I can also hear you. Good morning.
Fantastic. Thank you, and thank you for attending today's hearing. I will just start by asking each of you to state your name and position title and take either the oath or affirmation. I'll start with you, Mr. Regan.
Thank you. It's Peter Regan. I'm Chief Executive of Sydney Metro. I solemnly, sincerely and truly declare and affirm the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Fantastic. Thank you. And Ms. McPhee.
Rebecca McPhee, Deputy Chief Executive, Sydney Metro. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Would either of you like to make a short opening statement?
Yes, Madam Chair, I will, if that's okay.
Go ahead.
Thank you, Madam Chair and committee members. Appreciate the opportunity to appear today. I'd like to make a few opening remarks specific to Sydney Metro before taking your questions. I'll just take a couple of minutes. So firstly, and most importantly, everything we do in relation to property acquisition is covered by the Land Acquisition Just Terms Compensation Act of 1991. Since 2011, the property acquisition process for the construction of Sydney's new metro railways has been wholly guided by this legislation. I can confirm to the committee that on the Metro Northwest line, 78% of acquisition was by agreement with property owners or tenants. On the City and Southwest project, 82% of acquisition was by agreement. For the Metro West project between Bays and Westmead, that figure is 72%. And for the Western Sydney Airport project, Sydney Metro has reached 71% of acquisitions by agreement. Madam Chair, it goes without saying that I acknowledge that property acquisition and the process around property acquisition can be a very difficult one for those directly affected. For individuals, for families, for businesses, for people whose property has to be acquired to build infrastructure like metro lines. I understand their concerns and I acknowledge their frustrations. And I do apologise to them on behalf of Sydney Metro for any stress that they feel. Our job at Sydney Metro is to build railways using the least amount of land possible and as efficiently as possible for the taxpayer. In designing major projects, we make every possible effort to avoid the need to acquire private property and to use existing state-owned land. In some cases, however, there is no alternative but to purchase properties to allow for construction. In relation to the Sydney Metro Western Sydney Airport project, I can confirm that we are acquiring 1 commercial building and 19 residential buildings. Also being acquired are 4 properties that are vacant, as well as partial land acquisitions of 14 properties. We are going through a process set out clearly in legislation. Independent valuers are required to assess the value of freehold property in accordance with the Just Terms Act, using the appropriate valuation methodology applicable to each property. Madam Chair, each Sydney Metro Railway project is unique due to many factors, including geographical location and topography. These railway lines are designed to deliver fast and efficient metro services, and preferred station locations are determined to get the best customer and community outcomes. They are designed to service communities for the next century and beyond, and they are designed to grow with them. Finally, I would like to correct one assertion that the committee may be aware of: the comparison of Orchard Hills to Westmead Metro stations and sites. Orchard Hills and Westmead are an apples and oranges comparison. Westmead is an underground station in a highly urbanised environment at the end of a line. Orchard Hills is in a low-density area, will be built in a cutting, open to the sky, and will be a major construction site also required to launch 2 mega tunnel boring machines. Comparing the construction methodologies of the two is misleading. Sydney Metro West is about 25 kilometres long and completely underground. The 23-kilometre Sydney Metro Western Sydney Airport project has 10 kilometres of twin tunnels in 2 sections and 13 kilometres of railway tracks at ground level or elevated on a SkyTrain viaduct. It also goes through the International Airport site. For the committee's benefit, a more accurate comparison is Orchard Hills with Bella Vista on the Metro North West line, which has now been an operating railway station for more than 2 years, but was used in the construction of the North West Rail Link. Both sites are about the same size, but importantly, both sites are similar in how they are used during construction, namely launching 2 tunnel boring machines, running tunnelling support operations, storing thousands of concrete tunnelling segments as well as crushed rock from tunnelling, a grout batching plant, construction sites for the stations themselves, railway dive structures where the railway goes from the surface into a tunnel, and road bridge construction over both sites. It's a fact that most Sydney Metro construction sites are larger than the final station footprint. We need to be able to build the stations safely and efficiently. And we do that using the least amount of land that we can. I thank the committee in advance for your time today. I'm happy to take your questions.
Thank you very much. I'm going to start with the opposition. Mr. Mookie?
Thank you, Chair. And firstly, good to see you again, Mr. Regan. Thank you for joining us, as well as Ms. McPhee. Thank you as well for joining us. Can I just establish just a few more preliminary questions just about the scope of Sydney Metro's acquisitions? On the Western Sydney Airport line, just how many properties again are you acquiring?
19.
19. And how many of them are in Orchard
Hills?
And how many of them are in Orchard Hills?
So I believe that number, just bear with me. So we're acquiring 19 Orchard Hills.
So all the properties are coming in Orchard Hills, that's correct?
No, sorry, I apologise. So Metro West Sydney Airport, in total, there are 19 at Orchard Hills, and the broader number of Ms. McPhee will have that number to hand. She may be able to help me find that.
Absolutely, Mr. Regan. So there are 21 buildings in total across the alignment, but that is 62 interests that we're acquiring. So that includes leasehold as well as freehold interests across those 21 buildings. And of those interests, 21 interests are in Orchard Hills.
Okay, thank you. And just on the Western Sydney, the Bays Westmead link, do you have the similar number of numbers?
I can answer that one, Rebecca McPhee. So Metro West Westmead to the Bays, there are 115 buildings that we're acquiring, and in total that is 417 interests, freehold and leasehold.
And do you have the breakdown of those 417 interests by residential versus commercial or business?
I'll have to take that question on notice. I don't have that information with me.
But presumably that encompasses the Hunter Connection and others, so I presume it's quite a lot of business?
No, in fact, those properties are being acquired as part of a separate acquisition process for Pyrmont and the CBD. So the Metro West acquisition was in 2 parts, Westmead to the Bays, which is the 417 interests that I gave you, and the Pyrmont and CBD acquisition, which is ongoing at the moment, and that is 13 buildings, but that's 573 interests over those 13 buildings.
573 over those 13 buildings, got it.
Right.
And can you just take us through, I think Mr. Regan covered off where you are up to in respect to the Western Sydney Airport acquisitions, but have you started on the Westmead to Bays? How many of those 417 are completed? How many are not?
Yes, so I can answer that. So Westmead to the Bays, as Ms. McPhee said, there's 417 properties. And to date, 72% of those properties have been acquired by agreement, and the balance will be going through the compulsory acquisition process. For the
Sorry, Mr. Regan, just pause there. Have we 72% have been acquired by agreement? When you said the balance of the compulsory acquisition process, you mean the valuer general process?
Yes, that's right. I'm happy to give you more context if you wish.
No, it's okay. But you have completed all negotiations. It's not like there's another category of people who you are still negotiating with in respect to that part?
There are a small number of properties that we are still finalising those negotiations, but for the most part, that section from Westmead to the Bays, we've been through the commercial process, and where we've been unable to reach agreement, those properties have been gazetted for determination by the valuer general.
Yep, so it's roughly a bit more than a quarter. Yep, and where are we up to in the Pyrmont to CBD? What's the timescale for that?
So Pyrmont to the CBD, this stage, that was announced earlier this year, in May this year. We have commenced discussions with relevant property owners and interest holders. At this stage, we have not completed acquisitions in Pyrmont and the CBD.
But what's the timescale? When are you required to have this resolved in order to permit construction?
So we're working, we are in discussion with each of those property owners and interests. We're working to through next year to seek to reach a commercial agreement with the potential towards the end of next year to be looking at gazetting those properties for construction commencement in 2023.
Okay. Thank you for that. Can we just return now to the matters of Orchard Hills, if you don't mind? Did you have the opportunity to see the evidence that was given by the Orchard Hills residents?
I have not seen all that this morning, no.
Did Ms McPhee?
I have not seen that, no.
Okay, but presumably you are across the matter?
Well, yes, we're certainly across the process that we've been undertaking at Orchard Hills over the past couple of years.
Thank you. Have you at all times negotiated in good faith with those residents?
As far as I'm aware, Mr. Mookie, we have, yes.
Can you explain why we had residents tell us this morning that the first offer from Sydney Metro was the difference between the first offer made and the second or the final offer made was 70%, which is a pretty dramatic turnaround in property values. Can you tell us why that is?
Yes, so perhaps if I could start by explaining to you the process that we undertake, and I think it is very important that we do talk through the process as it exists. So firstly, we act under the policies of the government and the legislation, the Just Terms Act compensation. Under that act, we are required to take into account factors, the market value of the property, and also look at other areas where we can contribute to assist property owners. In the case of Orchard Hills, as is the case across all of our acquisitions, in doing so, we engage independent valuers to assist us in determining the appropriate price for those discussions. Those independent valuers are required to take into account all of the reference points that they can, including other property sales, market value data, to try and assess the appropriate level of offer and compensation. It is particularly challenging in an environment such as exists at Orchard Hills, where there are not a significant number of data points or where the market is moving quite rapidly, to enable us to continue to operate the process. I guess it's fair to describe it as a dynamic process. So during that process, we take into account additional information as it becomes available, other property sales, other market data. We have offered each of the property interests there the ability to have an independent valuer appointed for them as well. And we ask that if they wish to share the outcome of that or make any other representations, that can be facilitated and the two valuers can talk. What actually happens in practice is that as there is additional data available, we continue to have that taken under consideration by the valuation, the independent valuers, and they continue to update us. And so I think your question was why there is a significant difference between the initial offer and the offer further down the process. And that reflects that additional information that has been taken into account based on feedback and discussions with the owners, based on other property sales, based on other relevant data. And it continues to remain a dynamic process.
When the additional data point that caused Sydney Metro to revise its offer of what the residents say is upwards of 70%, when did Metro get that data?
Well, as I was explaining, there is a process that is a continuous process that has taken place since the initial discussions, and data as it has been available is considered by our independent valuers and taken into account.
Mr. Regan,
so I think there is probably fair to say that each of those properties is also treated separately and independently of each other, and they are obviously linked geographically, but there are different factors in play with different properties. And so we've continued to go through that process based on the individual factors and through discussions with owners and other data we can research.
I appreciate that, but I will press for an answer because the residents told us that a huge amount of stress and pressure would have been saved had Metro come to the table originally last September with a value that was closely aligned to their final position. In light of those residents telling us about the huge stress that they have gone under, which you accept that they have, to be fair, as well, I just do want to press, when did you become aware of the fact that your initial valuation was out to the point of about 70%, or alternatively, the additional data point arrived that caused you to say, well, actually, you know what, we can go back to the table and get a better offer to these residents? Did you become aware of that?
Yeah. So I think all the way through the process, there's been additional data, and the residents and the other property owners in the area have been advising us of their views as to data. There's not a single data point that we've relied upon or that our valuers have taken into account. As the process has evolved, whenever there is more information, that is taken into account for all the properties and for each property individually. So on the way through, as that data has become available, we've taken into account. I agree that actually, with the perfect foresight, the process would be different, but we don't have perfect foresight. We have to work through the process as the information becomes available and to try as quickly as possible. In doing so, we've offered each of those property owners the ability to have their own valuers to assist in that process and to help make the case for the individual aspects of their property and the overall market. And so we have actually strived throughout this process to reach agreement and to be able to pay the owners of the properties as much as we can in favour of trying to reach an agreement, but we are limited by the Act. And so we can only offer them what we have the evidence base to offer them for. And that's the process that we've been working through. I do appreciate, as I said at the start, that is not going to be a stress-free process, but we have done everything we can to try and get to an amicable resolution.
Mr. Regan, I invite you to take on notice if you can provide us with any particular time about when you've got that evidence point, because I just understood your answer to be that you always had evidence points and then you were talking to residents. But the point that I want to put to you is that the residents have said to us that they were making offers to Sydney Metro, repeated offers to Sydney Metro, and Sydney Metro weren't negotiating at all until effectively last week or the week before when you came to the table and increased your offer by 70%. How is it possible that we can reconcile what you're telling us, which is you have followed a diligent process, with what the residents are telling us, which is they couldn't even get Sydney Metro to the table to seriously negotiate? And I would just say that wasn't just one resident. That was effectively 5 of the 19 who have told us this morning, and then submissions indicate that it's far more than that.
Well, we have been open to reaching agreement throughout that process, and we have reached agreement with just shy of half the owners at Orchard Hills and 71% across the Western Sydney Airport line. During that process, we have attempted to reach agreement where we can, but it is a negotiation process where there may be quite different views as to the particular characteristics of a property or its worth. And so we have tried our best to understand that and to use the data points that are available. I might ask Ms. McPhee if she would like to add any further detail on that process. She has been quite heavily involved on the way through.
Well, yes, but Ms. McPhee, the point that I particularly am interested in is we have at least a third of these residents telling us that they couldn't get you to negotiate with them. Can you tell us whether or not there were any meaningful negotiations in this period?
Yeah, I can confirm that we have met with the Orchard Hills owners and tenants throughout the process, and we did even offer them the opportunity to meet with the Deputy Chief Executive. So I did personally meet with a number of those owners and tenants through this process to discuss both the construction requirements for those properties as well as the acquisition process. I am also able to say that there were recent important pieces of information we were able to take into account in making those revised offers to the Orchard Hills owners, and can take on notice specifics around those recent data points. But we were open to negotiations, and we did have multiple meetings with the owners through the process.
But one of the very simple ideas that the residents said that they put to you, two of the residents said to us that they suggested that you, rather than acquire their land as freehold, you would take a lease over their land, particularly if you're using it for construction. Now, this is a practice that other agencies, including Transport for New South Wales, have adopted in other policies. Why is it necessary for you to permanently acquire these people's lands when you're only intending to use it for the construction phase?
So I'll give you some context on that. We do go through a process on every piece of land of looking and considering, firstly, how to minimise the land take, and then the form of acquisition or tenure. And there are a number of factors that we consider. Firstly is the extent to which there will be permanent infrastructure as opposed to construction or temporary infrastructure. How long the land will be occupied with the construction, and what level of improvement or buildings on the land would then need to be demolished, whether the land would be similar in shape and form and potential use thereafter. And so the profile of the land, the earthworks, the drainage are all taken into consideration. There are cases where construction leases are used. It's less common than acquisition, particularly where there is a short-term requirement to acquire land that does not significantly alter that land, is one of the circumstances where that is looked at. However, it's often not actually practical or necessarily financially beneficial if the land has been materially changed and the purpose of the land is changing as well. So in the circumstance at Orchard Hills, some of the land will be permanently part of the railway infrastructure. Other parts of the land will be permanently part of the broader infrastructure that is built around the railway station and the railway itself, including utilities, so power, water, telecoms, the like. And some of it would be not in a form that could be returned because it is then part of a public domain, or it's part of...
Mr. Egan, I appreciate that, but we did a site visit to one of the properties, to the property that was owned by Mr. and Mrs. Vella, Mrs. Lauren Vella, and they told us that their land was, they got told by Metro that their land was being used as a turnaround bay for trucks, that to bring small, that's it. It's being used as a turnaround bay for a truck to come in, to rotate to the side and then leave. And they make a good point that if that's the point of their land, it doesn't meet any of the criteria that you just described, yet they're losing their land permanently for effectively what will be a short, well, relatively short-term turnaround for trucks. Like, I'm struggling to reconcile the processes that you're described with the lived reality of what these residents are telling us. Can you shed light particularly about maybe Mr. and Mrs. Vella's case as to how, given that they offered you or would like a construction lease, why that for their land that wasn't entertained by Metro?
So the whole of the land that's being acquired at Orchard Hills is required for extensive construction activities. And those activities, which will take place over 4 to 5 years, include storing spoil, removing spoil, construction and storage of precast tunnel segments, a grout patching plant, significant site support facilities, dive sites, construction and launch of boring machines, a very significant alteration to that land. And all of the land that is being acquired is being used for the construction purpose. And so within that construction purpose, yes, on that site, there are different uses within that site, but they are all part of a broader construction, which is a massive construction exercise.
Sure.
Will utilise all of that land and will considerably change the land from its current form.
Mr. Regan, I'm going to pass to my colleague in a second about this if he's got any questions. But I accept your point. You say that the like-for-like comparison here is between Orchard Hills and Bella Vista. And you made the point that Bella Vista was equally the site for construction. But equally, the residents of Orchard Hills have told us multiple times, including this morning, that they suspect that part of the reason why so much land is being taken is because to facilitate precinct revival and property development. I'm looking at what's happened with Bella Vista after it's opened, and I'm looking at your website, for which there are plans for 8,000 to 10,000 residents, homes to be built in Bella Vista on the sites that you compulsorily acquired for construction. Given that you are capable and you're legally authorised to do development, can you tell us when you're finished with this land, is Sydney Metro planning to build any homes on the Orchard Hills properties?
So thank you for that question. The land that's being acquired at Orchard Hills will all be used for the construction of the Metro Western Sydney Airport line.
But I'm asking afterwards, Mr. Regan.
Yes, similarly, the land at Bella Vista that was acquired was used for the construction of the Northwest Metro line. In the case of Bella Vista, there is a precinct development that is taking place around that area, involving a number of government departments, Sydney Metro, Landcom being part of those. At this stage at Orchard Hills, I repeat the comment that the land that is being acquired is for construction. Yes, the government has announced that there will be commensurate change in the land use around the station, and that there will be a high amenity precinct built in that area. The actual land use has not been determined, other than that there is an intent to have that kind of mixed use precinct developed around the transport infrastructure. The parties involved in that are cross government. There is no rezoning at this point in place. It is not Sydney Metro's decision as to what those planning arrangements and land use controls are. That rests with Department of Planning, Industry, Environment and the local councils. We clearly work with them, but the actual land use has not yet been determined. So I think it is sort of early in that process, and the comparison with Bella Vista, I would say, actually stands in terms of what was acquired for construction purposes, and it is very similar in terms of the size and the activities that will take place on those two relevant bits of land. Sydney Metro acquires the land for construction. There are broader government decisions around the land use and the planning, but if there is, some of that undoubtedly will include public space, public amenity and the like. If there is development of that land, then that is not something that financially accrues to Sydney Metro.
So if I could just pick up on that then, from what I hear you're saying, this land is acquired. So in particular, the land that Mr. Mookie was talking about for the trucks turning bay, it gets acquired at this point. It will be essentially trampled all over. We will have, potential for I guess contamination and all sorts of things to occur during the construction, but presumably that will be managed in a way that then allows that land to be developed afterwards. Is that correct?
So firstly, yes, absolutely. If there would any contamination on the land or construction impact will be addressed during construction, so there won't be contaminated land thereafter.
So, okay, so it's not that it's dangerous after that. It's just that it wouldn't be returned in the same state in which it was.
Correct. I don't know whether I actually can table documents, but I'm happy to provide on notice. I have some various pictures and things of what it would look like during construction and what the layout of it would be, and it is a very intense construction usage. So I will look at whether I could perhaps table those on notice or respond on notice with those, because it is quite an intensive usage of the site during that time. Thereafter, the government has announced that it will look to around the station, as is sort of good and usual practice around transport infrastructure, to provide additional transport infrastructure, so for interchange from other forms of transport, active transport, kiss and ride facilities, all of the things that you would expect around a train station will be provided. And then there will be further amenity provided both in terms of public space and some kind of mixed use from commercial or residential, but those decisions haven't been made as yet. So it's not a case of all or nothing, if I can say that. It's the centrepiece of that area would be the station and the interchange and the ability for people to access the public transport and connect via the metro, both north to certain areas and to connect to the main Sydney Trains network or down south to the airport, the Aerotropolis. And that is the intent around each of the stations, other than at the airport itself, that the stations are servicing the growth of that area for the next 50 to 100 years. So it's not a straight development play, it's about transport infrastructure.
So understand that in the future, it may be developed into something else, and probably will, given what we've seen in other equivalent sites. To the extent that the Vellas decided, though, that they would, with eyes wide open, knowing exactly what's going to happen to that land, still prefer to lease it than have it acquired, on what basis are you refusing the lease from a metro perspective? Yeah, so the challenge is that the site and the transport infrastructure and the development subsequently of that precinct around it may not naturally fit with the individual property lines or the alignment of what is there in the first instance. And it is quite a long period of time, 5 or 6 years of construction, that there will be such significant change to the land that actually, on balance, the practicality approach is that we acquire that land and we compensate for the market value of the land and the additional support that we're able to give to the property owners. It is something that we, as I said, looked at in certain circumstances where there's a limited use of land or land is returned, but for a similar, in a similar state to where it was first, where we have looked at construction leases, but on balance, the construction approach and the land acquisition approach has been where the land does have that significant alteration and with a change of land use, it is more appropriate to compensate that land value because we don't know what that future land use will be, but we do know that it will change. So in terms of, I guess if we're looking at the acquisition of this land for this project by Metro, it's not necessarily the case, is it, that at this moment in time, that land has to be acquired. From what I think you're telling me, and please correct me if that's not correct, is because you envisage that in the future, you may need more of that land permanently, or there may be other reasons, but that's why you won't do a construction lease? Sorry, the other way around. So all of the land that we are acquiring will be used for the construction of the line. Some of the land post-construction, post-opening, once the construction is completed, would not be needed for the ongoing operation of the line, but it would all be used intensively during the construction period. So but from Metro's perspective, there's no need to acquire that land. Well, acquiring the land gives us the ability to do the construction in the most effective and efficient way, and to have then the opportunity for the broader precinct use in the future, however the government may determine to do that, to have the flexibility to be able to do that in terms of the other infrastructure that needs to connect, the public space and the other facilities and the appropriate planned land uses, which could include development at the time. But the difficulty is each individual site is not individually separable through that process. That's been the challenge that we've been working through. And I understand the point that some property owners have been pushing there, but that's not something that we've been able to accommodate given the intensity of the use of the land. Would an alternative, though, not be for Metro to have a construction lease over that land, and then for in the future, if the government does decide to use it for other things, it could then do a compulsory acquisition process at that time? Well, from Sydney Metro's point of view, the compulsory acquisition powers that we're using under the Just Terms Act relate to construction of infrastructure and are not there for other purposes such as
property development, that it is our powers are limited to compulsory acquisition for construction.
That's right. So again, why? I guess if we look at the Just Terms Act and the stated policy of trying to reduce the amount of, and you said this in your opening statement, you're trying to reduce the amount of properties acquired,
yes,
and to do it as a last resort. Why couldn't we have, in this process, for the purposes of the construction of this particular site, a construction lease instead of an acquisition of the Vella's land?
Because the site itself, and I depending on the final alignment and the final construction, all or part of that site may or may not be available post-construction. But it's not just the station and the railway infrastructure that goes through there, it's all the supporting infrastructure, including new roads, other facilities. It is unlikely that land in that area would be completely untouched or unused in the future. And so the approach taken is to consolidate the land through that construction period and utilise that land as efficiently as possible to minimise the amount of land that's required. And then there is a decision for government thereafter around the future land use.
Yes, and some might argue that at that time there might be a need for compulsory acquisition of the land as opposed to a construction lease. I think the question is why you're preempting that as Metro.
Well, I guess that's a decision that would be a decision in the future, but whether that land was compulsorily acquired is not something that would be part of Sydney Metro's remit in that regard. So we're using powers for construction and
so
not
given,
for development.
I guess given the, as we've heard, the significant impact on these families who, through no fault of their own, have effectively had this done to them. There's a power by the government to be able to come in and to compulsorily acquire their properties. If we could preserve their right to at least have a lease over that land so that then they can choose what to do with it later, and they can enter a negotiation later on when it needs to be actually acquired. Wouldn't that be fairer?
It's probably not really my place to say what is fair. We're working within the terms of the Act and the requirement to pay the market value now. What you're describing is a different set of scenarios. And from our point of view, what we are trying to do is to compensate for the market value and for the additional costs and the disruption that those parties are put through and for the difficulty that they've gone through. And to do that now based on what we know rather than an uncertain land use decision for the future.
One last question before I throw over to Mr. Banasiak. I guess if we were to allow the Vellas to have a construction lease over the property and then to consider acquisition of that land for future use at a future time, the valuation of that land at that time would be much higher, would it not?
Well, it depends what the land, what the condition of the land and the planning requirements and the rezoning at the time is. But that's very different to the market value now. And one of the challenges is that, yes, the land value does change when new infrastructure is built and when the land use changes. But at this point in time, the process around the market value looks at the market value of the land now. It has been a challenge in this circumstance because the market values have been growing very rapidly. And you do end up in quite a circular situation as to sort of what is driving the land value increase. Is it entirely the infrastructure or are there other factors driving that as well? And in this circumstance, clearly there are multiple factors that are driving the land use change, but the development of the infrastructure, the transport infrastructure, is creating a future expectation of value. Yes.
So this current acquisition by Metro is done at prices based under the Just Terms Act that are, as we have heard, not necessarily of the amount that would allow these people to relocate effectively. But by acquiring now, we are effectively denying these families the possibility of realising fair value for their property later on down the track. Is that not right?
Well, I think the challenge is the length of time involved and the change in the use of the land and the nature of the property. It's not like the property that is there today would be returned in 5 or 6 years' time in the same form. And so the Act, but the Act sets out for us a process where we work through to compensate for the market value, the fair market value now, and the additional areas of support and payment that we are able to do so under the Act. And it is, as I said, very, very difficult for a small parcel of land as part of a bigger site to work that through on a case-by-case basis in terms of determining whether one piece of land can be returned or not. The level of change in this land is very, very severe.
Thank you. Mr. Manasiak, I'll pass to you if you have questions at this time.
Thank you, Chair. I've got a few questions. Mr. Eden, during your opening statement, you spoke about, I guess, the number of properties that were acquired through negotiation versus the actual compulsory acquisition process. I just wanted to break down those figures a bit, if you could. How many people accepted the first offer?
I don't have to hand how many people accepted the first offer, noting that it is quite an ongoing and iterative process. So I don't have that number to hand. I'm happy to take that on notice for you.
Okay, and perhaps you'll probably take most of this on notice. How many people accepted on the second or third offer?
I will take that on notice. As I said, it's an iterative process, so it's not just limited to those offers, unless my colleague, Ms. McPhee, has answered that, but we're happy to come back to you with more detail on that.
Okay, and obviously, what was the maximum number of offers made to a landholder, and what was perhaps the average number of offers made as well?
Yes, I'll come back to you on that. Are you referring, just so I make sure I come back with the right information, to the Western Sydney Airport line?
Yes, specifically with the Orchard Hill residents.
Oh, yeah. Okay. Yes, that's fine.
Okay. Just picking up some of your comments, you talked about paying the landowners fair market value for what it is now, but we heard evidence from witnesses this morning that stipulated that some of the reasons why the valuation was lower than they expected was for things that were potentially going to happen in the future. So they, one resident spoke about biodiversity issues where they've told us that they've lost $360,000 in valuation because of 3 trees. Another set of witnesses spoke about a change in the town planning around Cumberland, and that was being used to essentially offer them a lower than ideal valuation. So how do you reconcile your comments that it's fair market value now when you're taking in potential future impacts, particularly when they won't actually own the property when those impacts come into play?
Well, I think this is part of the complexity of the issue. So in taking into account the facts, as I was explaining, we have the independent valuers who do use as many data points as they can to get to a fair market value. And clearly, to the extent that something is in the future and hasn't happened, it is a lot harder to take that into account with a degree of certainty to something that is actually announced or committed or is actually a planning use that is in place. And so certainly at no point have we attempted to lowball or to try and underpay. What we've been actually trying to do is find ways to support us getting closer to the positions that the existing property owners or landholder interests were seeking. And so actually that's been quite an important part of the process for us, is to get those, to take on board the views and to try and find ways to be comfortable that we can justify a higher price. Now, we rely on independent valuers to do that, to help us justify that. And under the Act, we must be able to justify the price that we're doing. So there is a balancing act to be found in all of that, in trying to take those things into account and to make it justifiable under the terms of the Act, but to try and get as close as possible to what the landowners may believe that it's worth.
But there's nothing in the Act that actually prevents you from lowballing landowners, is there?
Well, we're required to pay fair market value, and that's what we're absolutely trying to do.
We heard evidence earlier that the case managers, I think, or as they're badged, relationship managers, weren't really helpful at all during the process. They didn't have any technical expertise or knowledge specific to the particular landholders' process, and essentially, the best way to describe them would be, I guess, a buffer between Sydney Metro and the landholder. Can you tell us what process or what level of training or knowledge these people go through to be a relationship manager, and do they actually have detailed knowledge of the individual case that they're managing? Because the evidence we've heard suggests that really they don't.
Well, certainly that would be a concern to me if they have not been useful, because certainly the intent is that they do help with the process, and that was something that was brought in after the government did undertake reviews into property acquisition, was that role of the place manager. I might ask Mr. McPhee to talk a little bit more about the role and how that works through the process, because certainly the intent of it is useful, and certainly not suggestion that there is a buffer between Metro is certainly not the case.
Yes, thanks, Mr. Regan. So I can confirm that as part of the process, each of the landholders and tenants are actually provided with dedicated personal managers and dedicated acquisition managers. So they have two separate contacts. The acquisition managers are trained as per the Centre for Property Acquisition standards in accordance with the Centre for Property Acquisition guidelines. And they have that standard training process that they all go through so that they can provide that informed advice to the landowners about the property acquisition process. The personal manager is there to be another counterpoint, and they are employed by Sydney Metro, so they are representatives of Sydney Metro, to provide, I suppose, more of a shoulder to lean on in the process to understand what their rights are. They provide support, for instance, like relocation support, helping affected landowners look for alternative properties, look for alternative schools. So they are intended to provide support. I'm extremely sorry to hear that may not have been the case in this instance. And they're certainly not a buffer. As I mentioned before, we've met on multiple occasions, and our staff are available 24/7. And as I said, I've also personally met with a lot of these landowners, and we offered that to them all. So I don't think it would be fair to say that we haven't engaged through the process. We absolutely have.
Okay. That is my time expired, so I'll throw it back to the chair.
Thank you. I'll just check if the government members have any questions at this point. Mr. Mallard.
Yes, I'm back, and thank you for your attention to the inquiry today and hearing from the members. I'm interested to tease out this discussion around your obligations under the Act in terms of payment of compensation. I mean, I've been involved in this debate in all my public life, from Labor's disastrous Metro Rail right through to this project in terms of compulsory acquisition of properties, and no one I've ever met has been happy about the property being acquired. One, because there's a lot of personal emotional investment and financial investment, perhaps if it's a business, and two, they always feel they didn't get the price that they expected or should have got, and that led to our reforms. Some of the disputes around that with regard to the West Connex, I think it was. So I'm interested in that dual responsibility you've got. You've got a responsibility to get value for money for the taxpayers, and we're here representing the taxpayers, not one family. And you also got to make sure that it's just compensation and it's got to be evidence based. And I was interested, just flesh that out, explain that, your legal obligation, how that works.
Yes, sure. So, and as you described, there is very much a need to balance those objectives and to try and take into account as much as we can and our valuers can give us in terms of ways that we can justify making higher payments to particular individuals based on circumstances unique to their property or in the overall context of the market. But there is a real balancing act. Also, in doing that, we have to be able to justify the use of taxpayer funds, and we need to be able to follow a process that is quite a strict process as to how we do that, and with lots of checks and balances in place around the process and the role of the independent valuers, the role of the place managers and the acquisition managers to sort of help people understand the process. But ultimately, as you say, it is very difficult, particularly there is always going to be significant sort of tension or stress when you are talking about people's homes or their businesses. And we understand that. And that actually does make this a very difficult place to be in, because ultimately the infrastructure that we're building, particularly for Sydney Metro, is something that will provide a broader community benefit for a very long period, and is generally infrastructure that people want to see built, and that they welcome the infrastructure investment. In trying to limit wherever we can the amount of land, private land that's acquired, can have its own challenges, and certainly we don't always have the right land in the right places or broader government land. Where it is available, we do try and use it. But the process itself sets out sort of this concept we've been talking about around the fair market value, and it also sets out the other areas where we can contribute, including payment of stamp duty to for a new property, including disruption, including sort of other costs on the way through, the legal fees, the valuation fees, and there's plenty of flexibility in that process for us to be able to support owners and affected property parties through that process, and we've generally offered different types of support on the way through, including advance payment of costs to assist. It's not always taken up, and some people approach it very differently to others, and that's understandable because everyone has a different view. Property is one of those things that it's not uncommon for the owner of the property to have a different view as to what it's worth than a buyer of a property. In our case, we're trying to sort of set ourselves aside from that, where we will work on the basis of the independent valuations that we get, and particularly at Orchard Hills, where we gave the property owners the opportunity to have their own independent valuation and asked them to share that with us or with our valuers if they wanted to. They didn't have to. And we're trying to give people as much information and support to justify, particularly when the land value has been moving around so quickly. And certainly in Western Sydney, there has been a lot of change, and some of that is clearly related to the level of investment in the infrastructure. So there is an element of circularity in that process, and certainly we work very hard to try and ensure that what we're doing is both justified and that we're not, that we're keeping within the need to deliver the project overall within budget, but we do set budgets for different aspects and include contingency in those, to deal with the fact that the market could move. I think that the key challenge in the legal construct that you describe is that the land that we acquire must be for the public purpose. It does get difficult when with the concept of betterment, where broader land holdings also go up in value because of the investment into the infrastructure. And that's where I think there is often disagreement as to sort of the extent to which that betterment and the investment for the public purpose should be attributed to the original landowner, or to the fact that that is something that comes once that infrastructure is developed. And that is the challenge that we sort of are working through and understand. We do get differences in view, of course. But the process is there to try and reach agreement. I would add as well that the process is also very clear that if agreement cannot be reached through that commercial process, that there is then the opportunity for a third independent party, the Valuer General, to make that determination. And that removes it from Sydney Metro. At that point, it's the Valuer General making the determination as to the worth. And then beyond that, if that is unacceptable to the owners, then they do have the right to further appeal that to the Land and Environment Court. So it is a process that is designed to have constant checks and balances. And certainly our objective is to get agreement before it gets to that point. And certainly sort of 70 to 80% is a good outcome in that regard, but it's still not a perfect outcome where we are unable to reach agreement with all parties.
I mean, we need to recognise that compulsory acquisition, the state pays for, correct me if I'm wrong, it's from my local government days, pays for the valuations, pays for the legal fees, pays the stamp duty that might be in the transaction.
Yes.
And we'll pay, I think that's discretionary, but relocation costs
Yes.
for the property. So it's more expensive to compulsory acquire property than to wait for it to be on the free market. Not that we can spend the time waiting around, but that's the situation. I think 20 to 25% dearer.
Look, that's absolutely right. We do have those additional costs, and we pay, and I think it's important that we do contribute to the owner's costs in that regard. And that continues throughout the process. If they're uncomfortable with where we get to in the commercial stage, we continue to pay those costs through the Valuer General phase and even into an appeal. So it is designed to try and mitigate that disturbance as much as possible. But it is a last resort for us because it is more expensive and it is also less certain for both parties, and it takes longer to resolve.
And I mean, government acquiring land, particularly the government is so engaged in a major infrastructure boom in our state. It's happening all around the place. I mean, Randwick Hospital being expanded, that was quite difficult, that acquisitions there. And but you've got oversight, like the Auditor General, the Minister, of course, himself or herself, Auditor General, our committee. So you need to balance that right. You know, the two competing intent, the two tensions. You know, what the owner wants and what the taxpayer should be making sure, and the access to make sure it's balanced correctly. So you've got the Auditor General always watching over what's going on. I mean, the Leppington Triangle, which has nothing to do with the state, and it's been cleared now, but that was Auditor General and some significant concerns around overpaying for the land.
Camellia as well.
Beg your pardon?
Camellia as well.
Well, you had your chance to ask questions, Mr. Mookie.
Just pointing out Auditor General.
Order. I don't think that was a question. I think it was an interjection.
My question was the observation that it's a serious responsibility to get that balance right.
And it is a responsibility that we take very seriously. The key aspects of these processes also that we've really tried to continue to improve over time is trying to give people as much visibility and notice as to the process, and to be able to work through and to try and address issues early in the process and try and find alternatives. As Ms. McPhee mentioned before, that can include things like assisting in relocation, finding new schools, all sorts of things, to try and mitigate the impact, because it is a big impact, and we see that. And it is a matter of trying to minimise the disturbance on the way through. But that issue of the also protecting the taxpayer dollar goes right back to the start in terms of the way that the route alignment works, in trying to kind of find the right sort of combination of the alignment of the projects itself. And we do try and we're very, very considered and very detailed in the analysis as to where different parts of infrastructure would be located to try and minimise the overall impact, but to provide the best transport outcome long term. And that is a trade-off that we need to work through case by case.
There's two more lines of questioning, but if my colleagues, government colleagues, want to jump in, just yell out, so I don't actually take up all the time. But one is your so your team that does the compulsory acquisition team is within Sydney Metro team, which is like a subset below Transport New South Wales?
Yes, so it is a separate team, although operating on a fairly consistent basis. I might ask Ms. McPhee to comment.
Does it operate does the acquisitions team operate across Transport New South Wales, or they're isolated sort of silos, each one's? I mean, they've probably got unique skills they need for each type of transport, but is that where we're going?
Yes, so if I can answer that one, it's Rebecca McPhee. So Sydney Metro does have our own property acquisition procedures and our own property acquisition teams. So that property acquisition procedures provide the framework for Sydney Metro's land acquisition programs. And they do comply with the Property Acquisition Standards and Just Terms Act. And we do review them in accordance with any policy, procedural or legislative change. And I think it's also worth noting that we undertake fairly regular assurance reviews and audits of those processes to ensure that they do comply and that they're applied in a way that their application is in a way that still continues to meet those standards and policies of government.
It's not a reflection upon your team, but I have heard talk in that so-and-so's team has learnt their lessons is better, this team hasn't, or whatever. Is there peer engagement? Is there learning shared between Metro? Had some problems. Still people complain about Metro. The Balmain Leagues Club site the other day were in complaining. I mean, hospitals and schools, roads, water infrastructure, all these things. Are there crossovers of learnings between the different teams?
Yeah, there absolutely are, and there's been a recent process undertaken at the request of the Secretary of Transport for us to ensure that we do work together and align the processes and procedures. The teams are learning from each other, and they are also learning from the Centre of Property Acquisition, who set those standards and provide guidelines, advice, support, and training to our staff.
The last thing I want to touch on, and I heard you saying that the acquisitions you're doing are for transport, construction related use. What the future of that land may, whatever form it comes out in, as you observed, it might not be the same sort of parcel in terms of boundaries and usages. It's a matter of government policy. And I spent 2 years working for the Mayor of Liverpool and was very involved in the planning issues around the railway extension, which we finished later half built, to Leppington, and I'm just looking for the name, Edmondson Park. The contrast between those two rail centres is really stark. Edmondson Park largely was federal government land or state government land. Landcom managed it. It's a dynamic and working transport hub, interchange hub, with a diversity of housing on that supports it. Right, Leppington, which is fragmented, privately owned land, is just a dog's breakfast. It's terrible. Even Mark Latham talks about it in the chamber all the time. You know, it's just not coherent because different landowners aren't ready to go to market, aren't ready to start selling. So this is a sensitive point, but there is, in terms of logical planning for these transport infrastructures, the billions of dollars that we're investing, to have a more of an overhaul, coherent plan for the precinct. You agree?
The broader precinct plan is really essential for the long run outcome and to delivering not just a single mode transport outcome, but particularly the integrated transport outcomes and everything from the accessibility of the station from a walking and cycling and through to new forms of transport going forward. We're providing here for something that is for the next 100 years, and certainly a well-designed precinct with sort of a coherent timing of development and coherence of placemaking approach and wayfinding and coordinated approach to the way that people can interchange and interact with that precinct is a much better outcome than one that is kind of fragmented, or a railway that opens with nothing around it in terms of the broader activation of that precinct for the public purpose. And I think we've seen that on the development so far, and the two you mentioned. If you look at sort of the activation around the precincts on the Metro Northwest, you can see how much this kind of infrastructure sort of positively changes the broader environment for the community because it is planned. In this case, that planning is not just Sydney Metro, we're involved in that, but Department of Planning, Industry Environment, the local councils, and also in this case, the federal government who's contributing into this project as well. And all of those have an interest in the overall outcome, and a lot of engagement with the Western Parkland City Authority as well, and the Greater Sydney Commission. There's a lot of different views that get taken into account in determining what those precincts should be and where they should be located. So it is much more than just the initial construction that is in play, and certainly that longer term outcome clearly works better when it's done in an integrated fashion.
And the one thing the community, the commentators, the so-called experts, the planners have been saying to us for 20 years is they want government to do coherent strategic planning and deliver infrastructure in a timely manner. And it doesn't work if the land ownership, as Leppington is a good example, is fragmented and stagnated and not coordinated correctly. Yeah.
So the intent here is that each of the stations has a precinct plan that is addressed with all of the broader stakeholder group, and that would move forward, and Metro will deliver the bits of that we're asked to deliver to assist in that broader precinct.
Okay. Well, let's end my questioning, Madam Chair. Thank you for that.
Thank you. Mr. Mookie.
Thank you. Can I just a couple of quick questions. If you have the answers now, it'd be great. If you don't, feel free to take these on notice. Just how much has been spent on acquiring properties in Orchard Hills?
I don't have that to hand. Obviously, we're still
Ms. McPhee?
Working through that process.
Do you have a number or estimate? How much are we talking about?
I don't have those numbers.
Is your acquisition budget around Orchard Hills circa $100 million? Was that it at the outset?
So we haven't set out the individual property budgets.
No, I'm talking about the collective across all these properties. Was it circa $100 million?
So the budget, like we do across the project, so for construction, for property, for all of our costs, we have initial estimates and we have contingency and additional funding. As time moves through the process, we adjust those based on information.
Sure.
With construction, it's to do with tenders. With property, it's to do with progress. So we haven't sort of put out an individual budget allocation for
Mr. Egan.
Part of the overall project.
Yeah, sure. On notice then, can you just tell us what the cost has been of acquiring the 72% by agreement for Orchard Hills? Equally, the value of the remaining 28% if it was to be paid at Sydney Metro prices, and can you do the same for the Metro, the Westmead Bay precinct of the 72% acquired of the 417 interest, just what the cost has been? If you don't mind taking that on notice, that would be great.
Well, to be clear, we'll see what we can provide, but the concept of projects that properties, that are with the valuer general. So the value general to determine.
I'm talking about the ones.
There's not actually a concept of a Sydney Metro price.
Sure, fine. So then maybe give us the data for what you've paid by agreement then.
We'll see what we can provide.
Well, Mr. Piggin, you have been talking about value for taxpayers. You have been talking extensively about value for taxpayers in response to very good questions from Mr. Mallard. So I just want to understand how much have we paid for these acquisitions, but I'll move on. Sydney Helicopters, which has gone public, and I've asked you about this before, Mr. Regan, at estimates, if you recall. At the time you went across it. I presume you are now. This is a helicopter business that amongst its major clients include the Rural Firefighting Service, and for whom it spent most of last year putting out bushfires. They have said that they've not been in a position to negotiate with you in good faith, and that in fact the actions of Metro have effectively destroyed their business. This is a slightly separate category to the other residents, and we'll be hearing from Sydney Helicopters tomorrow. But I wanted to ask you to give us an update as to where Metro is up to when it comes to this particular Western Sydney business.
Sure, thank you. And I'll give a little bit of information, and then Ms. McPhee, who's been involved directly in those discussions, can further update you. We have, again, been applying the approach that we're required to apply through the Just Terms Act. And we have sought to reach agreement on that particular site for some time. There has been extensive engagement. We have not been able to reach agreement. There is a significant gap in expectation, it's probably the best way to describe it. But we have worked through the process and as best we can. That particular property owner, I understand, is not comfortable with the position that was offered and has gone through the value general process, which has also come up with a value that that property owner is not comfortable with. And I understand they have taken the opportunity, which is their right, to appeal that process. We have worked at all times to try and compensate for the interest in land that they had, the leasehold interest that they had, and to assist them in finding a new site. We have paid a significant amount to assist them in that process to try and find a new site and to compensate them as required and to go as far as we can.
The thrust of their position, Mr. Regan, is that they need enough money to build a helicopter base proximate to where they can use it to, amongst other things, help the RFS. And their view seems to be that none of these factors are relevant to you. And as a result, and look, to be fair to you, it might be legally that they can't be. But the gist of their position is they move, but they need to build another helicopter base because it's not like running 8 helicopters from a backyard is easy. And Sydney Metro has never negotiated with them on good faith about finding either a suitable property or, for that matter, an adequate amount of compensation. So if you wish to respond to that, because I will be asking this question today, I wish to be fair to you, if you wish to address their principal criticism of you.
Yes, so I might ask Mr. McPhee to comment on that, because certainly we have genuinely attempted to reach agreement with them. So,
Yes, thank you, Mr. Regan. So I think it's probably worth noting, as Mr. Regan mentioned, that the acquisition in question is of a site at 23 Wentworth Street in Clyde. That is actually government-owned land. It is owned by Crown Lands, and we have acquired the leasehold from Crown Lands. So this is the leasehold interest. So that lease was set to expire on the 30th of June this year, with one option of 5 years to extend. So that's the leasehold that we're acquiring. With respect to your question around our engagement with Sydney Helicopters, we did extensively negotiate with Sydney Helicopters over a period of 16 months. And we met with them on 11 occasions. And I met personally on one of those occasions with Mr. Harold. So we have genuinely entered into a process to try and come to a commercial agreement for that leasehold interest.
Can I just...
Sorry. No, in terms of alternative sites, we did pay for both our own civil aviation experts, and also we have reimbursed Sydney Helicopters for their own expert advice to identify suitable leasehold alternative occupation places for them to operate their business from. And we did identify an alternative site, and our basis of offer to the business was on the basis of relocating to an alternative leasehold site.
Mr. Regan, can I ask you, have you acquired 43A London Road, Orchard Hills? Do you hear that, Mr. Regan, or?
Yeah, sorry, I'm just checking my notes. I just want to make sure I comment on the correct property. Just see whether Ms. McPhee knows whether that site has been finalised.
So all of the Orchard Hills sites did gazette last Friday, so on the 1st of October. So from a legal perspective, yes, we do own the land. But in terms of whether we were able to reach commercial agreement, I don't actually have that.
Can you take that on notice? And can you equally on notice tell us just how much you paid for 43A London Road, Orchard Hills? That would be good.
We'll see what we can provide. Clearly, if it's not resolved, then we won't be
You might find that it probably is, Mr. Egan, and the figure might be public, but already. But either way, whatever information.
Well, I'm happy to look into that for you.
Thank you very much. Just some follow-up questions in respect to the evidence that you were giving about Miss Jessie and Mr. Jesse Villa's property. You made the point that, look, you can't really return it to them in the same state, but it's the case, is it not, that you actually, has Metro ever told the residents, those two residents, that actually after you're done, the land isn't going to be used by any roads or any infrastructure linked to a public purpose, and that in fact it's basically going to be the same parcel of land just without any home on top of it?
I think Metro's been quite clear that we're acquiring the land that we need for construction, and that land post-construction won't form part of the railway, but might form part of broader infrastructure, but not all of it will. I think we've been very clear about that.
But look, but Ms. Vella, Mr. and Mrs. Vella are making the point that they offered you the right to demolish all improvements. They offered you, they acknowledged that the land would be changed and that the tunnel is 20 metres under their land. And then on top of that, they're making the point that Metro has said to them that their aim won't be impacted post-construction and that effectively it'll become vacant land. And so it returns to the main point, which is they think that you should have leased it. My question to you is, Mr. Egan, you're describing this as basically you've looked at it as a whole of things approach as opposed to parcel by parcel. But aren't you required to look at this parcel by parcel and deal with each parcel of land according to its own individual circumstances about whether or not you can acquire it, what you pay for it, and whether or not you can return it?
Yeah, I think as per my previous answers, that is exactly what we've done.
Okay.
Can I ask, is there a difference in the approach of Sydney Metro when acquiring land from effectively, from a family, as opposed to from a corporate interest, from a developer, or from, is there a difference when somebody is basically residing on the piece of land that you are acquiring in terms of how you deal with them?
There are some additional elements of compensation for residents as opposed to corporates, including stamp duty that can be paid on a new property. In terms of our approach, the objective is the same, that we are working under the same Act. The Act is not differentiating in terms of our approach in that regard, but there is an additional element of the personal compensation that we look to ensure that is included in that package. But certainly, overall, we are attempting to achieve the same thing, to acquire the land, the minimum amount of land that we need, and to do so in a way that provides certainty. There are particular circumstances where different kind of arrangements are used, but they tend to be sort of at the margins, or where there's a sort of a relocation of sort of complex businesses, where we might look at different types of approach, but you don't pay the same market value if you're relocating some of those critical business activities. So for the most part, it's the same approach that's applied.
So there's no difference between the government negotiating with, for example, a property developer or somebody who might have their own legal department versus negotiating with a family who have no legal expertise and are relatively...
Yeah, so as we described before, we pay for the legal representation. Parties, big or small, would need, and we work with them. In terms of large corporates, there's sometimes a different set of discussions because they're not living in those properties, they're business properties, but the intent of the process is the same. And certainly we work to try and reach agreement, and if we're unable to reach agreement through that process, then it goes through to the Bailiff General to determine. And certainly, the numbers I quoted in terms of the percentage that we can reach agreement. There's not a huge difference in those percentages between commercial and residential as to where we are able to reach agreement. Certainly, it's always our objective to reach agreement with the owner.
And is it always the case that so you say that Metro will pay for the legal representation? Is that always after the fact, or is money ever provided up front?
Money can be provided on the way through up front, and we've offered in a lot of circumstances to do that. As far as I understand, in the Orchard Hills case, that hasn't been accepted, but we have offered to pay advance payments. We do make advance payments when on a case-by-case basis, and we're very open to that.
Thank you. I'll hand back to the opposition for the last few minutes of my time.
Thank you. Mr. Regan, residents have made the point that you have been using the draft Cumberland plan view in order to set, I guess, a benchmark. So, is it actually legal for you to be using draft plans to inform compensation decisions and your approach to negotiations?
I think the valuers and independent valuers that we use take into account a number of factors around likely impact on value. And certainly, I would be very concerned if it wasn't legal for what we're doing. We ensure that we are applying the appropriate terms of the Act, and we get advice to confirm that we are. There's no intent, but there's no intent, as I said before, for us to find ways to underpay.
Look, I accept, Mr. Regan, it's not intent. Like, you wouldn't be using this plan as an intended effort to reduce the value of compensation that is payable. But at any point, did you make inquiries to your valuers as to whether or not they were using that plan?
I'm not aware of the specific details of the case you're talking about. So.
Well, I mean, look, it's multiple residents have made the same point, right, across the Orchard Hills matters.
I'm happy to take that on notice. I don't know on that very specific point.
Does Ms. McPhee know? Because it's not a small part of certainly how they perceive these negotiations have gone. So I'm wondering whether or not we have any further information about whether or not Metro, Ms. McPhee is not, you can answer affirmatively or negatively, Ms. McPhee.
No, I'm happy to take that on notice.
But to what extent do you familiarise yourself with the criteria that your valuers are using to decide value?
So the independent valuers are required to take into account anything that could impact the value of the land under the Just Terms Compensation Act.
But at what point in time?
At the time of the acquisition, anything that could impact the value.
So, Ms. McPhee, the residents have this view, right, that the Cumberland plan apparently was considered by your valuers and resulted in a markdown of the value of the land. Yet the obvious property development that's going to take place afterwards was not considered as a factor that would uplift the value of the land. They certainly have made the point to us that they feel like the criteria that is being used as to what creates uplift and what creates a deterioration in value is basically at your discretion. I mean, can you understand the frustration that they would feel if they're told that a draft plan for Cumberland will drop the value of the land, but the government's intention to do a precinct revival has no bearing on the value of the land?
I think that there is another element in play here, which I think is important. I think it goes to Mr. Mallard's earlier question, that one of the requirements of the Act to ensure that government is not overpaying for land is that in consideration of the market value of the land, the valuers are required to exclude any uplift as a result of the investment. So any uplift that is associated directly with the building of the metro station must be excluded from the valuation.
And to be clear, that is not at our discretion.
I think my time has expired. It's the government's remaining time, Chair.
Yes, thank you. Mr. Mallard?
Yes, sure. Mr. Farlow, do you have any pressing questions? That's all right.
Nothing from me, Mr. Mallard.
Thank you.
Mr. Martin.
Good to see you again. I haven't seen you since a few hours ago. So, Mr. Ogan, a little bit of a history lesson here down memory lane. Were you involved at all with the CBD Metro that the previous Labor government started in Sydney?
No, I wasn't.
So, any of your team come from that period? We were talking Metro.
I think there are some in Sydney Metro who were involved in that previous iteration in the late 2000s, I believe.
Yeah, I mean that project. I was involved as a councillor, and it wasn't a compulsory acquisition of the Woolworths building, but the building was to be demolished, and the process of evicting tenants was underway, and some of the offices that the city council owned. And then when it was cancelled, the city got tens of millions of dollars of compensation, and across the whole metro line, there were properties acquired, and people were moved out, and government acquired them. So they would have had to be put back on market. Would have been hugely expensive for the government.
Yeah, I'm sorry, I'm not aware of the detail exactly sort of how that panned out.
Oh, so your CBD Metro Rail, it's the same basic.
Different organisation. The Sydney Metro in 2018. So different organisation, but it might be a question worth directing to Transport for New South Wales.
Oh, I might well do that. I mean, there was a very expensive $100 million or more in compensation paid by that previous Labor government. So it's not unique to have these difficulties in terms of acquisitions and for infrastructure, even putting aside the fact that was cancelled. But these are difficult processes to go through.
I think it is difficult to find that balance. It's very different to procurement of infrastructure itself, where the standard position is that we competitively tender and you can get sort of a market price that way. These transactions are inherently more bespoke because each property needs to be dealt with on sort of as a case by case, but also taking into account the broader picture of the infrastructure in the precinct that sort of surrounds it. So it is a challenge. We take our obligations here really seriously, and we really try to find a way to reach agreement and to use the tools within the Act to do that wherever we can. It's not always possible, but there are mechanisms in place under the policies and the legislation that then allow the Valuer General or the Land Environment Court to further determine that if necessary. And I would reiterate, we continue to pay people's costs and try and minimise the impact on them on the way through. But it is a difficult area, there's no doubt about it. And it's one of the big challenges for us at the front end of any of these projects, because we also need to acquire the land on a critical pathway to enable construction of the project to be able to meet the broader transport objective.
We had reference to the helicopter business, which I was reading up as well. It reminded me of the Speedway at Parramatta, which big controversy about that, but that's actually Crown land, and at least had a mechanism for it to be acquired at some time in the future. It's been obviously leased out for a long time. And I'm on the inquiry, along with a number of members here, on the Northern Beaches tunnel, and some of the construction sites are remediated former tips that are Crown land still, or even a golf course that's Crown land. But there's still, they are still difficult processes, because the community has a great sense of ownership and passion about some Crown land that they're taken to be part of the community's land. So it's not as easy as it sounds.
Well, look, it's certainly very complex, and I think the challenges on the Western Sydney Airport line differ from the challenges on Metro West, which differ from the City of South West and the North West. They're all case by case, and you are impacting communities and businesses in different ways. And certainly, the challenge with a surface railway is very different to a tunnel railway. A tunnel railway has less impact other than at the stations or those sort of service facilities, but ultimately still has an impact. So we try and limit the impact in the route selection and the way the project is put together. But there are trade-offs also in the costs and the usability of the railway, tunnel versus untunneled in different sections that also need to be taken into account, and the journey time overall. So it's not always exactly the case that the quickest way from A to B is a straight line, but certainly as far as railways are concerned, that the topography, the distance between the stations, and the overall journey time and broader outcome is something that's heavily taken into account in those considerations at the time. Once government has made the decision to go forward with a railway, and effectively in Sydney Metro's case, we're a delivery agency. That's our job, is to then deliver on what has been decided. And this process is a difficult process. We agree, and we do try and do that with as much empathy as possible and try and get to the outcomes wherever we can to ensure that then the public transport infrastructure can be built. And long run, the outcome of that public transport infrastructure is clearly sort of city shaping. But I don't deny that there are difficulties in the way we get there.
In an urban planning context, I would think, tunnelling, which is a technology that's become much more adept at and cheaper at doing, is probably a better urban planning outcome than a rail line on top or freeway on top. Is it also economically, would it be probably the same as compulsory acquiring land to put the line across the whole landscape?
I think tunnels, the construction cost of tunnel is significantly higher.
Okay.
And I think surface construction is not as expensive as tunneling, but yes, you've got the land take associated with that and the broader impact. So where we do operate at the surface or on viaduct, we put a lot of effort into trying to minimise the impact on the environment so that you're not cutting the precincts in half, and a lot of effort goes into that and to other things and then achieve.
So the decision of government to tunnel, a big part of that is to minimise the disruption on the surface to lives and businesses and communities by compulsory acquiring, because you're saying it would actually be cheaper to
well, certainly, and it depends what the route, but we're under a less built up or developed area. Rule of thumb, it's going to be more expensive to tunnel, whereas opposed to coming under, say, the Sydney CBD, where tunnelling is really the only option. And Metro West is entirely underground, and it does limit the level of surface impact, but there's trade-offs again, because the stations are much more expensive to build, and so there is a need to balance that. The West Sydney Airport line, like the Northwest Metro, has the advantage of going through some areas that are not as developed, and so it can be built faster and can be brought into operations more quickly by virtue of not all being underground. And so there are trade-offs in that are taken sort of into account at the investment decision and the business case stage. But certainly once those decisions are made, then sort of our role is to ensure that we build the railway as efficiently and effectively as possible and acquire the property in an appropriate way.
Thank you for that, Madam Chair. You're giving me the eye.
Yep. Your time is up, unfortunately. That does conclude today's hearing. To the extent that there were questions taken on notice or any supplementary questions are going to be forwarded to you, you will have the standard 21 days, but the Secretariat will be in touch. Thank you very much for your attendance and for answering the questions today. It's been incredibly informative. That concludes our proceedings. I understand we'll be back again tomorrow. All right. Thanks very much. Bye now.